Hey. It's a good thing I was monitoring myself because I'm like, oh, I'm not hearing myself. Now it's working. All right. Good evening. Yeah, now we got it. All right. We can take this thing out here. Always with the technical difficulties. Can never start without technical difficulties. But yeah. Oh, I know. Yeah. No, I realized that for some reason my mic reset itself, so I had to go in and do it, but we are good to go. So yeah, we've got news even tonight. Breaking news tonight from the Canton Board of Trustees. We have heard that Kevin Albert, Detective Kevin Albert of the Albertsons, the Alberts, the McAlberts, however you want to do it. Good evening, Margaret. Thank you. Thank you for coming out. Has been put on administrative leave, paid administrative leave, but administrative leave no less, until an outside investigation is complete. What is that? I haven't watched the meeting yet. I was getting ready for this. I was working at my full-time job before coming here and doing this. So I haven't had a chance to watch the meeting yet, but I am looking forward to that. But yeah, so it's an investigation conducted approximately 2 years ago. Now, follow up on this. This is from Sleuthy Goosey on X, who is an excellent read. Follow up on this. On 6/12, Michael Proctor was confronted on the stand about getting drunk with Kevin Albert, and Kevin Albert leaving his badge and firearm in Michael Proctor's state-issued vehicle as they drove back drunk from conducting a cold case. On 6/13, Kevin Albert was placed on administrative leave from the Canton. On 6/13, oh, he was placed on administrative leave on 6/13. Oh, why? Yeah, no, exactly. So I love this too. Now, Chief Rafferty, perhaps you can inform the public why the Sallyport video you turned over was inverted and missing 40 minutes of footage. Yeah, so that I believe that was 2022 when they were coming back from the thing. Yeah, so he was been on administrative leave since the day after the testimony. Oh my goodness. And it's just now coming out. Oh my God. What in the wide world of sports is going on out there? Yeah, no, yeah, exactly. That it is. It's so one person got up there, asked for $12,000 because the school had to have an unexpected meeting. $12,000 for one meeting. Oh my goodness. That's crazy. This is crazy. So we've also had this. So this came out tonight that he's been I was reading this earlier, but I didn't catch that he's been on administrative leave since 6/13. That is nuts. And then we have the filings. So we have a couple of filings from. So we've got the defendant Karen Reed's motion to dismiss filed by the Alan Jackson, basically saying that they have heard from jurors. Yeah, no, that's so crazy. All these dates are coming together. And they talk about the outside investigation until the outside investigation. Who's conducting that outside investigation? There is so much news that is yet to come out. I mean, it's just day after day, drip, drip, drip. And then we have this filed by their attorneys saying that jurors have reached out to them saying that their decision to quit on those charges was reached by the jurors that they had agreed that count 1 and count 3 that she was not guilty of. So what are those counts? Well, we've got them right here. We've got count number 1. This is the biggest count right here. And so let's pause into that. So Commonwealth of Massachusetts, Commonwealth versus Karen Reed verdict slip. Murder in the second degree. This was the big charge right here. Murder in the second degree. Not guilty, guilty. Right? Unanimous decision of all 12 jurors. Then we have slip number 2. Manslaughter while operating a motor vehicle under the influence. Now, this is the disputed charge. This is the charge that they're saying that there was differences. So let's look at 3. Let's go ahead and look at 3 right now. This one is leaving the scene of an accident resulting in death. So from what I've gathered from some of the talk that's out there was this one and 3 meant there was intent, right? There was intent to leave the scene of an accident. And of course, the murder charge has intent with it too. So now we'll look at the charge that they were deadlocked on, which if you look at the, let's go ahead and look at the filing, that it was 12-0 agreement that 2 of the 3 charges against her were not that. Count 1 and 3 that they had dismissed those charges. And that count 2 they were deadlocked on. Now, in this filing, I believe it is in this filing that they said initially it was a 6-6. Okay, no consideration for murder 2. Manslaughter started pulling at 6-6, then ended the deadlock at 4 no, 8 yes. This is a tough one because, as you know, from what I want to go through tonight was what I felt and what a lot of people felt was the deciding testimony, right? Which was the 2 experts hired by the FBI to go through and prove or disprove what had happened, right? So let's go ahead, look at the jury slip for count number 2. And this was the one that they fought on too. As you all remember, there was quite a bit of fighting over this charge, right? So we had manslaughter while operating motor vehicle under the influence, right? Not guilty. Guilty of offenses charged. So manslaughter while operating a vehicle under the influence of alcohol. So manslaughter while operating a motor vehicle with a blood alcohol of 0.08 or greater. Guilty of lesser included offense, involuntary manslaughter. Guilty of lesser included charge of motor vehicle homicide, felony OUI liquor and negligence. And so this one's still, yeah, exactly. Jury instructions is what got them. And I want to know what the instructions they received. Yes, I totally agree. What exactly were in those jury instructions? And that is a good point. We should probably go over those at some point in time. So but in order to find her guilty and to have 8 people say that she's guilty of one of these, now, we don't know which one, she still would have had to have struck him with her car. And so they still would have had to have been under the belief that an accident occurred, that she was, even if she didn't realize it, they're still saying that there was an accident that occurred. There was some way that he was hit by her car. So I want to go and let's go ahead and get started on me find it here. I brought it up. I'm not at the exact moment, but we will get there. And we're going to use Miss Burkhart's telling of the trial. So let's go ahead and get this started. Oops. Let me know if you guys can hear it, or if you can't hear it, or if it's too low, too loud. What?
And it's the dreamboat.
Oh, yes. The crash daddy, as Miss Brandy likes to call him. All right, so.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor.
I think we can go ahead and speed up the first part of this a little bit.
Last name for us, please.
Daniel Michael Wolf, last name spelled W-O-L-F-E.
Dr. Wolf,
go to 1.5 speed on this because
this known as ARCA, A-R-C-C-A.
And what is ARCA exactly?
So ARCA is a forensic engineering consulting firm. We have a variety of.
As we said, these two experts right here were the big part of most people's online. I mean, most of the witnesses throughout this trial were dismantled on cross-examination. There was no doubt. But these two witnesses at the very end of the trial seem to have the most impact on most of the people watching it. So I think, how much, especially over Trooper Paul, whose ridiculous testimony was just absurd, but you still had jurors that got to manslaughter, and so I don't
include human
understand
factors,
how
biomechanics, crashworthiness, accident reconstruction, just to name a few.
Based on your title, it sounds like you're the director of the entire accident reconstruction format for ARCA, correct?
That is correct.
What sort of contracts does
go
ARCA
ahead
routinely
and
engage
turn
in?
that off.
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government as well as the National Hockey League on player safety. So we're involved in a number of research projects as well.
Is there other
So these guys are very much involved in. Oh yeah.
Or human factors issues?
In terms of beyond the parties that I just listed?
The U.S. Department of Defense?
Yes, the military, yes, the Army.
Tell me a little bit about the work that you've done for the Department of Defense.
Well, that was before my time, but I'm aware of projects that dealt with working on vehicles that were over in the Middle East, where they basically designed energy-absorbing seats because there was injuries when the vehicles were going over IEDs.
Is ARCA known both nationally and internationally? Is it recognized as a leader in accident reconstruction issues?
Yes.
As the director of
Yeah, so I mean, these guys' bona fides were ridiculous, right? These are the experts of experts. If the dog bite expert, the lady who testified before them was, she's one of the preeminent experts as far as dog biting and scratches, then these guys, as far as accident reconstruction, are the best of the best.
I mean, and the human factors that are associated
and
with
just any kind of.
Can you give me a synopsis of the professional discipline
of how things work on the human body and how it reacts to different things.
To collision events. I always like to think of it as if you open up a puzzle box and you dump the pieces out and you've got a bunch of pieces and you're trying to piece together the evidence to see how everything fits to get a clear picture.
And what is the application of human factors to that process?
So to give you an example of human factors in the field of accident reconstruction, so I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night, there's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of how the drivers respond based upon the hazard.
I don't even know how to spell conspicuity.
Depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them.
Dr. Wolf, as an accident reconstructionist, do you investigate and reconstruct both passenger vehicle issues, commercial vehicle issues, motor vehicle, pedestrian issues, all of the above?
Yes, I see all types of accidents.
And how long have you been doing this work with ARCA?
A little over 7 years now.
What education, training, and background qualifies you to perform the duties that you just described for the jury?
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
What additional training or experience do you have as it relates to accident reconstruction in addition to the formal education and the PhD?
Certainly. So in addition to my undergraduate degree and my PhD, I've continued to take courses through Northwestern University in crash reconstruction. So those courses have included human factors, lighting. I've taken courses on electronic vehicle data, photogrammetry, three-dimensional laser scanning. So I've continued to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as ACTAR, which is the accreditation.
So all this is just his getting accepted as an expert witness.
Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on map scenes, evidence from photographs, things of that nature?
Absolutely. So photogrammetry is the science of extracting information, if you will, out of photographs. So things dimensionally about an object spatially without ever actually physically seeing the object or inspecting it.
So you don't have to be at the scene to effectively and scientifically reconstruct it to your satisfaction?
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk, it's, the accident happened 5 years ago. Some I've even had 10.
Okay, so there was something right there. So the only time during the trial that anything was mentioned about the other investigation was, I believe it was Colin said the feds or the FBI, right? He slipped up and said the feds or the FBI one time on the stand. And I'm sure a lot of the jurors wrote down the notes and everything. But then when he gets into it later, that the defense didn't hire these people, the prosecutor didn't hire these people, but he did just say civil litigation right there. So could that have given the jurors the thought of maybe these guys were hired for a civil suit or by the insurance companies?
Access to the vehicle at that point, it's going to be a long shot.
Dr.
I mean, just trying to figure out anything in their testimony that would have still left the door open.
Yes.
Or Karen to have
the Society
hit
of Automotive Engineers,
John.
SAE.
I mean,
I'm also a
that's
member of the National Association for Professional Accident Reconstructionists.
That's kind of what I wanted to watch these guys for.
The
Was
Society of America, and also the
how did that door get left open?
Would you say in your experience in your career have you reconstructed or
How did we still get to
I don't actively track that. If I had to estimate at this point in my career,
8 to 4
and how many of those
guilty
1,000,
of manslaughter? I don't understand.
But several hundred. As I mentioned earlier, a great excuse me. A great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day,
right, exactly,
in the evening and night hours. Just
yeah,
having difficult.
They had they had to have ignored. Yeah, basically, at least 8 guilty had to ignore Lucky, the plow driver, Dr. Russell with the dog expert, the pathologist. He was right before Dr. Wolf here. And then the 2 ARC doctors, the 2 ARC PhDs. They had to ignore all of that. So
try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
Done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
There's that word. There's that kinematics word.
We do a number of tests in order to look at the interaction between pedestrians and vehicles.
Kinematics.
I did most recently where we were evaluating a vehicle essentially rolling over a pedestrian. So we wanted to understand the vehicle dynamics as well as the interaction between the pedestrian and the road surface. So we conducted testing at ARCA to evaluate that.
Does ARCA have any other disciplines other than just accident reconstruction?
Absolutely. So as I mentioned earlier, we have crash worthiness. So again, that's where you're going to be looking at the safety of a vehicle. How does it perform in a crash? We have human factors, failure analysis, premise liability, and biomechanics. Testing at ARCA to
as an accident reconstructionist, doctor, do you or have you studied or tested the forces that are at play between objects interacting, a human being interacting with a vehicle, for instance?
Yeah,
that's part of what you do.
Yes, sir.
Describe that.
So we use hybrid instrumented dummies at ARCA for our testing. So if we want to have an understanding that an occupant in a vehicle, the forces that they might experience, or for any metaphor, again, if it's an instance where you have something that ends up falling on someone's head and you want to have an understanding of the forces involved in that, we perform testing with hybrid dummies.
I'm just now noticing his tie.
Papers in the field
How much I like it.
Yes, sir.
Describe those for me.
So I have a number of papers in the field of lighting and optics. I have a recent publication that deals with Toyota and Lexus vehicle control history records as well.
Is that called Toyota Vehicle Control History, Sudden Braking History Recording Characteristics?
Yes, sir.
All right. Was that specific to dealing with vehicles and their interaction with other vehicles and or pedestrians?
It involved looking at the various triggers that system is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a...
So I'm also, I do believe that I read that the Toyota system from the Lexus, from Karen's Lexus, was not able to be, the data got messed up. correct? And I'm gonna have to go back, but I believe the data was messed up, so they weren't actually able to. I even saw somebody say something the other day about a soldering iron, like they took a soldering iron to the infotainment system. But yeah, no, that's right. It did come out in trial that they weren't able to get the data down from the infotainment system. So the only thing they were able to get down were those stupid key cycles. So.
What's the
And
problem
we've
here?
got an approach. All right, let's go ahead
Pull up
and
a summary.
fast forward through.
Yes.
Okay. There we go.
Now you're.
Yes, you can move on.
That's right.
You've been qualified in other courts to testify.
I had to
Fine.
think about that for a minute, but they
You were not hired by the defense in this case, correct?
there we go. So here it comes out. All right, I'm gonna slow this down to normal speed because I think this is important here. You know, I'm just speculating, but
You and I had never met.
That's correct.
You did not you did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Unetti.
No,
Matter of fact, you'd never heard of this case.
that's correct.
You were hired by another agency not connected in any way to the defense.
Okay.
Is that right?
Correct.
And not connected in.
just parsing little things here. He says agency. So when I hear the word agency, or initially when somebody says agency, you think of a government. Oh, it could be an insurance agency though. But when you hear the word agency, especially coming from an attorney in something like this, you would think government entity. I would
any way to
initially.
the Commonwealth. Is that right?
I would think
So your analysis
government
and your conclusions
agency.
and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
What
Is
is
that right?
When you did your
Leading.
analysis and conclusions, well, let me ask it this way. You finalized
you?
a report, you and your team.
How would you
correct? That
characterize
report is
your
contained-
relationship?
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
We didn't, the defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right.
There's that word again. Agency.
Goes without saying, but
Agency.
I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
So if it's a big if they go to a retrial, will you think they would pay a different company to do more testing? I mean, something's got to give
As a matter of
to
fact,
get over that hump.
I've never asked you specific questions about your testing before today.
That is correct.
Okay.
Good to get that out in front of the jury.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
In terms of them reaching out,
Correct.
yes.
And I called you ultimately after receiving your report, asked if you join us and testify, correct?
That is correct.
Okay.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked the case that's now pending before the court?
Yes, sir.
Ooh, I don't
Was
know
your
what
team
happened there.
asked to do this by the agency that ultimately retained you, not us?
Okay, there's that word again. Agency that ultimately retained you. So
That's correct.
we're getting it in there that there's an agency. We're just not allowed to say whatever it is, but he's using that word again, agency. So when the jury's hearing agency, you would think government agency would be the first thing in their mind. And could they be thinking it's a insurance agency? Maybe. I mean, that would be the other issue in insurance, or, you did say something about civil litigation earlier.
Who would
So
ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a
all right, we'll speed this back up a little bit. Just go ahead and go back to 1.5. Yeah, I see. Yes, I have.
mechanism
She
for the
was,
injuries of Mr. John O'Keefe.
she was totally, there there are a lot of people doing that.
And
No
what was your
lie.
focus? If he's talking about the injuries to Mr. O'Keefe, what was your
What,
focus in your reconstruction and
yeah.
analysis?
I would simply say it was looking more at the damage to the vehicle.
Okay, so in terms of your team and the responsibilities of each of the team members, you were more focused on the damage to the SUV, and Richard was more focused on the injuries.
Oh yeah,
suffered
no,
by the
they
vehicle, correct?
they were
I
definitely
think that's a
popular.
fair characterization, although
Both
with the
of
caveat
them
that we
were
worked
pretty
together as a team, so we
popular.
weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Understood. Were you provided or did you review certain materials in furtherance of your consultation in this matter?
Yes.
What were you provided?
We were provided photographs of the incident location. We were provided photographs of the Lexus. There were a couple of incident reports that we received. I could look at my report for the full list, but those were the ones.
You can go ahead and do that, Doctor.
Do you have the report with you?
Yes, sir.
I have a copy of it. Is this faster?
Sure. If you-
Yeah.
Bev will let Doctor do whatever he wants. Not Mr. Jackson. The doctor is free to do what he wants.
No doubt. She was digging these
What's wrong with
guys.
I
How
like
many
the ties.
categories
It's
of
modern.
Materials were you provided?
Monochromatic.
Provided, it would be approximately 10.
I like
could
it.
you list those off for the jurors, please?
It would be the Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021
Lolly.
Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570.
Lolly likes to put a lot of emphasis on the, they didn't actually, examine the car itself or anything, but
Report of autopsy and autopsy photographs.
as he talked about earlier,
Based on
they're
these
trained
data that you were
to do
provided,
that.
Were you able to satisfactorily, to your mind, satisfactorily engage in the consultation that you were hired to do
Yes.
and come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs, from the scene specifically?
So from those photographs, I
And I think coming up
was able to identify
when he starts getting into what he did, especially with the Canon, there are a lot of people that are just and I really want to focus on that. So when we get to that, I'm going to slow it back down. But it's still not clear from a lot of people today what conclusions he actually
there were
came up
fragments
with.
of transparent red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime. Yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is. I
Right.
noted that in a lot of these photographs, I didn't see a whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not really having a great understanding of where was it relative to all the other evidence.
Or when it got there?
Okay, so there's testimony that the investigation sucked.
Correct.
Um,
You didn't
based
do
on
the
your review of
investigation very
described in the
well.
report, did you get an understanding of what the Commonwealth's theory of the case is, specifically Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that the allegations before the court were that Mr. O'Keefe was struck by the vehicle?
Objection.
Sustained. Ask it differently, Mr. Jackson.
He's leading.
Did you perform an accident reconstruction specifically focused on determining whether or
Okay,
not
leading
damage to the
question. All right.
Lexus was consistent with hitting Mr. O'Keefe?
Yes, I think that's a fair characterization.
And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle?
Yes.
Okay. During your analysis, did you note the damage to the vehicle?
Yes, sir.
Yes, you did. You came
So
in at the
primary
perfect
damage was to the
time.
right taillight. It appeared to be fractured with the majority of the lens cover, so that clear and red plastic covering missing from it. In addition to that, if you're looking at the back of the vehicle, to the left of that, in the area above there's also another tail lamp assembly on the lift gate. So above that assembly, there was a small dent along with some paint chips on the bumper, more so on the wraparound section as it kind of curves around to the right side of the vehicle. There appeared to be some superficial scratches as well in that area.
Was there any other damage or deformation that you were able to glean from your review of the photogrammetry? Damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like
He's
that?
a very popular, very popular
Common in
Dr.
Dr. Wolf.
That there's some sort of bumper displacement and or sheet metal deformation that's concomitant to that.
Absolutely. Assuming a pedestrian is positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes.
That too is wood. And I don't know that they didn't, right? I don't know that the DA office didn't try to find an expert that would testify that their theory was correct and nobody would actually do it. I mean, you're putting your reputation on the line when you do that, and you're not going to find very many people. What was that? The Depp Heard trial, the crazy doctor that Amber Heard got to testify. That was like, what the heck was his name? You're not going to find very many people like that. You're really not. I mean, I can't.
You certainly could see deformation to body.
I got to look that up.
Liftgate or the quarter panel as well.
Is that especially true at higher speeds, meaning above 15 miles per hour or so?
Oh, absolutely, yes.
Was there any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
Spiegel.
No, it was, again,
Dr.
it was
Spiegel.
really confined to just the taillight, a very isolated portion of the vehicle.
Dr.
Spiegel.
Spiegel.
Investigation, did you note information concerning items that were supposedly found on the bumper?
Yes.
What was that?
I believe it was noted there was 2 apparent glass fragments located on the top bumper cover.
What's the significance of the presence of those items or the lack of materiality of those items in your view?
Well, again, I think it's going back to the scene evidence. Again, we knew that there was glass fragments, what appeared to be from a drinking glass, at the scene of the alleged incident.
Yes.
Is there any glass consistent with the glass that was
Crash deconstructionist. Oh,
absolutely.
absolutely.
Anything from the car to the Lexus that would account for that glass?
Okay, I think I understand. So the taillight.
That guy was, I mean, oh my God. You couldn't have made that up. I mean, how
Itself is not comprised.
he didn't even understand a lot of the, even what the math thing, oh yeah.
Of any glass. It is
That
all
was
plastic.
crazy.
So that damage, or I should say, that glass on the top bumper cover could not have come from the right taillight.
Absurd.
Now, based on your review,
I keep using the word absurd because every day of this case, every day of this trial got more and more absurd. You think it started out, and I put a post up last night too on X about just how absurd everything just kept getting.
the information that was provided to
Every
you,
single
any
day it
testing
was something
about the
else.
vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you describe what that testing
All right, here we go.
So we
All right.
performed, again, this is with Dr. Rentschler and I working together on this again. We performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Let's take those one at a time.
I'm going to go down to
how would you describe
1.25.
The drinking glass test.
Certainly. So again, from our review of the evidence, we knew that we had an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Rentschler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture.
I'm going to interrupt you right there. You and Dr. Rentschler formed that theory and wanted to test that theory, correct?
Yes.
You were not told that theory by the defense because you've never met us.
Correct.
You were not told that theory by the Commonwealth. You've never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data.
Yes.
Got a broken drinking
Yep.
glass, a broken taillight.
Nope.
Let's put them together.
Take it down to
and figure
normal
out
speed.
if the
You're
drinking
correct.
glass could be responsible for the taillight and vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this. Let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay. As a matter of fact, and importantly, while you were doing your testing,
Oh yeah,
had
no,
you ever
exactly.
even heard of the Karen Reed case?
No.
So getting back to that testing, and I interrupted your flow, you were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially, you can think of it kind of as a giant
Look at him.
cannon, but
Look at him.
It had a
He's even starting to giggle here. He's got a smile on his face already when he thinks about this.
a
Fun
barrel,
job.
and then there was a valve that would open rapidly, and directly behind that
And
was
he's
a
trying not to
pressurized
giggle.
vessel. And depending on the pressure, the PSI of that vessel would determine essentially the speed at which that
Right.
glass would be projected into the taillight.
Oh my goodness.
So you literally built a cannon?
Yeah, it's pretty awesome.
Yeah, it is.
Pretty cool job.
That's so funny.
Tell me what the
So
result of the
funny.
testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed 2 different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Rentschler, he indicated that that is a reasonable speed at which an adult male or an individual, for that matter, could throw a drinking glass at the taillight.
Had anybody
Yeah. So, and, you know, if you're throwing it like a baseball, you got to figure that, you know, somebody, especially John's size, I bet you he could chuck a baseball pretty freaking hard. Right. But the drinking glass is not a baseball. It's got a probably weighs about the same. If it's the rocks glass, like he's trying to think of, you're actually about the right size too. So you know, 30, 40 miles per hour probably is a good, I mean, that, yeah, these guys are the experts for a reason, but it's not out of the realm of possibility.
anybody told you any specific, let's see if I can rephrase that. Had anybody indicated that there was any evidence whatsoever that John O'Keefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Rentschler and your team?
Right. Yeah, exactly. Exactly.
exploring
Short distance
sort of every
speed too.
possibility?
And that's what I was thinking. If this actually happened, which, you know, if this actually happened and he actually did throw the glass at the car, and, you know, that would explain quite a few different things, then, you know, how far away was he? I mean, was it when she was pulling off? Was it like he was 6 feet away from the car? So, you know, I wouldn't think it would have to be pretty close to do this. I think less than 10 feet would probably be about right. I think if you get any farther than 10 feet, then you're really pushing it. But
You're working a little bit in the blind.
obviously the wind didn't have anything to do with it. But
What was the reason that you decided, or you and your team decided, that you wanted to approximate how a grown man could throw a glass at a taillight?
Well, I think we wanted to have an understanding is when a projectile such as a drinking glass interacted with the taillight, would we get damage on the test taillight that was consistent with that of the subject taillight?
Understood. So based on your
and so in this, I mean, think about this as a juror. Now you're sitting there as a juror, and you've got this expert that has come into the trial, right? This very well qualified expert, okay? And nobody throughout the trial, the defense, the prosecution, nobody has said anything about a drinking glass being thrown at the taillight. Nobody has talked about the drinking glass causing the damage to the taillight. So now as a juror, you're hearing an entirely new theory about the taillight damage. You've heard what the prosecution thinks is that his arm did it. You're hearing that, you know, nobody from the defense came out and said that the taillight was busted out by that it was a conspiracy, but it was intimated. It was definitely intimated during Buchanan's testimony when they were talking about Proctor being near that taillight, right? So that was, it was implied. So now you have a whole new theory of the taillight damage just being thrown at the jurors.
Your theory, were you able to approximate the damage on the taillight?
Yes.
Describe that for us.
So as I mentioned,
So, and even, you know, somebody had, yeah, no, exactly. These, you know, it was completely stupid that the taillight would cause that damage to his arm. Absolutely, 100%. There's no, absolutely no way that that was what happened. But then I had other people argue me that the experts had said that that they had concluded that the drinking glass couldn't have broken the taillight. That they had
speeds were at 30 and 40 miles per hour.
They had concluded that it didn't happen, and I don't remember hearing that.
So what we actually achieved. So the achieved speeds were at 31 miles per hour and 37 miles per hour. So there's just depending on how the glass leaves the barrel and some of the rotation can affect some of the speed. Or ultimately the end result speed to that. So what I will say though is that with the 37 mile per hour projectile into the taillight, we noted and observed that there was damage that was consistent with that of the subject tail lamp, and that the test tail lamp had the majority of the outer lens fractured and missing, broken into pieces, as well as some underlying damage to some of the internal components as well.
So they were able to, he just confirmed they were able to simulate the same damage with the taillight. They were able to make that happen.
Are you saying, well, let me ask a different question. You were able to replicate the damage to the taillight using a pneumatic cannon firing a glass at 37 miles
Reminder.
per hour. Taillight, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Yeah, no, that's, I mean, you're right that we know that the glass, I mean, this is also, it's also confusing what actually happened. It really is. But we know that that there was glass in the yard, right? We know that the glass on the bumper did not match the glass that was found near John O'Keefe. You got to figure if he does, he didn't really say the distance. No, and he didn't say the distance of what they did on the testing either. That never came out. But you got to figure if it's going to explode the taillight and it's going to explode the glass, then it is going to travel. But then how is the glass found where he ended up? And so
by a person simply holding
how does the jury hear this? Yeah. The one that took 3 trips on the bumper, right? Exactly. The one that went home that night, got into the garage. She pulled in the garage. She stayed in the garage, right? So that and the magic frozen hair, if she's in the garage, and I know she had I guess the door was open to the garage or whatever, but still, if that's a heated garage, then the magic hair should have thawed out. But then it gets thawed out. Then it goes driving around. It goes back to the one piece of hair. Then she goes back out driving around. Then she goes back to her place. Then she goes all the way to her parents' house. And then it gets towed all the way back to the Sally Port. And there's still glass on the bumper.
Hit by the car driving in reverse.
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the taillight, if you think about where where it meets the lift gate into where it starts to wrap around to the side of the vehicle, that's only about 6.5 inches in width.
All right. When you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable at that point, correct?
Correct.
All right. So the glass is hurling through the air at 37 miles an hour and hits the static object that's resisting. And that smash is what produced ultimately the taillight damage that you were able to replicate. Is that right?
Yes.
If a person were holding in his hand the glass and the taillight were to hit that hand, the hand would not remain static, correct?
Objection.
Sustained. Ask it differently, Mr. Jackson.
If the
How is that?
taillight
How is
were
that
to-
not allowed? Her, man, everything she's sustained throughout this trial. I mean, most of that, a lot of it's probably appealable, to be honest.
The taillight
What would
make
happen to the
contact
hand
with
if the
person
taillight hit
holding
it?
The glass. Would that replicate what you did in terms of you're firing a glass into the taillight? In other words, are they apples and apples?
No, I don't think it would be the same.
Okay. Why is that?
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, when we're talking about the taillight itself, that 6.5-inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Rentschler, inconsistent with the injuries to the arm.
So given everything in your investigation was revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection.
Sustained.
In all the information that you were provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Right?
Objection.
Sustained.
He's
What?
being very leading.
Yes.
What in
He's
the?
just being leading.
Okay,
He's in the report. You guys that your formula
let's go through
brainwave
here.
with me
All right, we're coming back.
without just putting it to him
Yeah.
directly,
Yes,
but you
thank
can't
you.
put it to him directly.
What information, if any, were you provided that suggested that John O'Keefe threw a glass at the taillight?
No information.
What information, if any, were you provided that suggested that John O'Keefe may have had a pneumatic cannon with him that night?
I'm not aware of any information regarding that.
All right.
Oh, that's interesting.
You also did some testing concerning a drop test. Is that right?
Correct.
Sneeze.
about that.
Bless you.
Drop testing.
Certainly. So, again, through discussion with Dr. Rentschler, it was my understanding that Mr. O'Keefe had a skull fracture on the back of his head. So we wanted to do an evaluation of the interaction between the
So yeah, so when I focused on that cannon in that test,
back
but
of
I
I
only watched this once,
Again, talking
so-
about that instrumented dummy again, we used the instrumented hybrid head form to perform a drop test to evaluate the forces of an interaction between a tail light from the Lexus and the human head.
okay.
What height did you choose to perform this drop test?
7.5 feet.
Why did you choose that height?
Well, if you calculate it through physics and the acceleration due to gravity, that would equate to an
Something Trooper Paul never did calculate anything through physics.
impact speed of 15 miles per hour at that height.
And what was the significance of 15 miles per hour?
Well, that was essentially kind of a starting point for us, if you will. So I will tell you that in reverse, 15 miles an hour is fast. I don't know if you've ever looked at your speedometer when you're pulling into your driveway, reversing into a parking stall. Most people probably don't go more than 5 miles an hour or so. So 15
Right,
miles an hour
yeah.
in reverse is fast, especially when we're talking about, it's my understanding it was nighttime. There was winter conditions, potentially wet or icy roads. So again, that speed is going to be what I would say on the high end for going in reverse. So also in addition,
So there's something else that the jury should take in. They should be taking notes on that. And everybody that I've seen that has tested it out, and I've done it a little bit too, is going backwards is so 24 miles an hour in reverse is ridiculously fast. And yeah, I mean, that's the wheels spinning. You don't go 24 miles an hour in reverse. That's your wheels spin 24 miles an hour in reverse, but you don't travel 24 miles an hour in reverse. I'm sorry, that just doesn't happen.
It's my understanding through discussion with Dr. Rentschler that at 15 miles an hour, you start to see significant injuries to the human body when it makes contact with a vehicle. And I think one last point is that we needed to pick a speed where, again, this is kind of just us brainstorming, where we would have damage to the taillight, right? It would fracture it, but it wouldn't completely obliterate it. So we knew if we chose a speed, for instance, of 40 miles an hour, we know we're going to completely essentially explode the taillight. But if we do 1 mile an hour, we may not do anything to it, right? So we kind of had to pick a middle ground to again cause damage to the taillight.
I'm not touching that one. Not touching that one.
With following that testing, what was your conclusion with regard to
just putting it up there,
whether or
not saying
consistent or
anything.
inconsistent with the damage to the truck, the taillight was consistent or inconsistent with making contact with John O'Keefe's head?
Yes,
At or above
yes.
15 miles an hour.
Was the black straw's
Speaking
fault.
to a damage perspective, the
I blame the
15
straw.
mile an hour interaction
You are correct.
between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject tail light was less than that of the test tail light.
So if we were to, if I
So
were to
she'd have
ask
more
you whether or
damage to
not
her
there
car.
would be more or less damage to the taillight if you increase the speed to 24 miles an hour, what is your conclusion?
Well, you're talking about significantly more kinetic energy. So if you just think about it
Yes.
from, again, a kinetic energy standpoint, kinetic energy is equal to 1/2 times the mass and the velocity squared. So if you're squaring that velocity and you're going from 15 up to 24 miles per hour, you're going to get a significant amount of more energy associated with
Yes.
that. Probably, I
An
could pull up my
actual
calculator, but you're
equation.
probably looking at 2.5 more times energy than the 15 mile an hour test.
Which means 2.5 more times the damage to the taillight,
Certainly.
which you did not see in your review of the materials, correct?
Correct.
So what is your opinion or conclusion as to whether or not the damage to the taillight was caused by striking John O'Keefe's head?
From a damage standpoint, it was inconsistent.
I want to shift gears back to the injuries that you saw concerning Mr. O'Keefe's arm, his right arm. During the course of your investigation, did you look at photographs and investigate?
He had you at hello. What are you talking about?
Yes, sir.
What's the width?
Hi,
of
my
the
name is Dr.
taillight,
Wolf. Ah.
Specifically from where it meets the lift gate to the left side. I'm sorry,
I love it.
to the side of the vehicle, the right side of the vehicle.
To the right. So yeah, as I mentioned earlier, that is about 6.5 inches. It starts to wrap around to the right side. So really it's even though the taillight continues, it's not projecting out on the back end more. It's again wrapping around. So
Yes,
in
the
terms
cannon.
of the width that is facing the rear, if you will, it's about 6.5 inches.
And you noted that there was a dent and some paint chips that you identified above the lift gate, correct?
Correct.
How far away from the right side of the vehicle were those scratches and that dent?
Approximately 20 inches.
What was the significance of that distance?
Well, again, to go back to your question about, I think if somebody was holding a drinking
Read
glass,
this
right, and their arm was
back up a
extended to
little
cause that
bit.
damage, or if it's theorized that those dents and chips were from that. Again, the thing that sticks out to me is that you have essentially the Lexus taillight.
So ask another question.
What's the significance of whether or not there was damage between the dent and the taillight? In other words, that 20-inch area. Was it dented? Was it harmed in any way?
So in terms of, again, if we're talking about, again, looking at the back of the vehicle,
Yeah.
we go to kind of where
Yeah,
the
exactly.
tail lamp just meets the lift gate. As I mentioned, there's another lamp assembly on the lift gate itself. There's also a chrome trim piece above that, and then certainly the body paneling to the lift gate itself.
Right. And their whole theory of, I mean, it's just, there's not enough time, right? If their theory that his arm was extended, the taillight hit his arm, exploded, cut his arm through his sweatshirt, right? And then he spun around and went flying, right? There is not enough time to do all of that. You're either going to hit him and cause him to spin around and get thrown, or the taillight's going to explode and the pieces are going to go through and cut his arm. You don't have time for all of that to happen. It's just not, it's not spatially possible as far as time goes. It's just not.
What stood out to me is that between that dent and the fractured taillight, there was no observable damage to that area, which I would have expected had an arm been positioned there.
Correct. Yep. There would have been significant more damage than, yeah. Right. She saw her move up 3 different times, and then, you know,
Or did you calculate?
saw her up until 12:45. It was hilarious, you know, like go back to Colin Albert's testimony. Like when he's under cross, it's I don't remember, I don't know, I don't remember. But what time did you leave the party? 12:10 a.m. exactly. Yeah, shut up. You did not.
Project him a number of feet, for instance, 30 feet in one direction or another.
Everything I remembered exactly.
Take a distance out of it. Break it down.
What?
I'll ask you the same question without the 30 feet.
Okay.
Were you able to calculate, or could you calculate?
Yeah,
the force
no,
that would be
exactly.
required to strike a person on his outstretched
And
arm?
nobody, you know, some people saw the Jeep, but the, you know, the Nagels and all those folks, there was no Jeep. They didn't see the Jeep there.
Hard
So
enough to spin around and project him a number of feet.
I know there's enough reasonable doubt in this entire case for none of these charges to, oh yes. Yep. I have that. Yes. The one by microdots. Yes. I've seen those videos. It's absolutely really, he's done some great work.
If you're talking about only an
This
interaction
one
between
here.
the arm
Yes,
and the
check
back of
out
the vehicle, there wouldn't be any
microdots.
projection. Again, if you think about this, the arm weighs
It's got
about,
some
again,
really
Mr.
good
O'Keefe would be about
videos.
11 pounds. So you still have, you know, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially, the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Mm-hmm. Yes, thank you.
There you go.
Is the absence of the damage that you described, between the dent and the rest of the vehicle, with the exception of the taillight, is that
Yes.
consistent or inconsistent
I
with
agree.
striking an outstretched arm of a human being?
Objection.
I'll allow that.
That would be inconsistent, in my opinion.
So right now he is saying that their theory about this and the arm getting hit by the thing is inconsistent. It's not possible.
And what is your opinion, doctor, as to the amount of damage that you would expect to see
Yes.
at
Oh yeah.
15 miles per hour or above
Yep.
on the taillight, if in fact that vehicle were moving in reverse and were to strike something on a human body, for instance, an elbow
Nope.
or
Yeah,
arm?
exactly.
I'll allow that.
I'm sorry, can you repeat the question?
Probably not.
Sorry.
I'm trying. Physics, that's fun.
I'm trying.
From your testing, what would you expect to be? What would you?
No, that's another very, very good point. Like I've said this too, head injuries. We all know what happens with head injuries and how much they bleed and how, you know, where is all of that blood? And I never heard throughout the trial, and maybe it came up under the Emmy's testimony, but how much blood did he actually lose? Because it's something that would have been accounted for in the autopsy. Is how much blood did he actually
That
lose?
taillight were to make contact with a part of a human body, for instance, an
And,
elbow or an arm.
You know, I
at
know,
15 miles an hour or above. What would the level of damage be? As
and I know you couldn't, you know, because of the snow, you couldn't make it part of the testimony, but yeah. I want to go back just a little bit. Okay.
Elbow or an arm at 15 miles an hour or above. What would the level of damage be as compared to the damage that you actually saw?
Well, if we compare it to, again, looking at the drop test that we did with the hybrid head, which weighs about 10 pounds. So again, if we're talking about now a human arm that's comparable in that same weight, we certainly would expect to see a comparable level of force
Yeah, I'll
and
definitely
damage.
check
So as
that out
mentioned,
too.
If the arm is outstretched across the right tail lamp and into the liftgate section, I would certainly expect to see deformation to that body paneling, even potentially the tail light on the liftgate itself and that chrome piece as well.
Based on the entirety of your investigation, your entire team's investigation, all the testing that you did, all the biomechanical testing and the engineering and the physics testing that you did.
Here we go. We're getting
In
to
your
the
expert opinion, was that taillight damaged by striking John O'Keefe in the head?
Objection.
Sustained.
What's
In
wrong
your
with that?
opinion, was the taillight damaged by either striking Mr. O'Keefe in the head or the arm?
Objection.
Sustained.
And reproach?
Yes.
how is this
You
not
under-
allowed?
What's
This is
the
so
problem, Judge?
ridiculous.
Yes or no questions are not leading. Only if you're telling him which answer is correct. And Mr. Jackson just was caused.
Okay, here we
You are
go.
unmuted.
See what happens.
May I, Your Honor?
Yes.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion,
Oh,
is the damage to
John
the taillight
O'Keefe.
consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, jurors, we will take our morning recess.
All right, there we go.
You are muted.
I thought we took the more.
All right, so we've introduced the theory about the cup hitting the taillight. We've introduced the theory of John throwing the glass at the taillight. We've had an expert just completely say that the prosecution's theory that the damage happened because of this is not what they came up with. Actual reconstruction experts said the damage did not happen because of hitting John O'Keefe or hitting a human head or a human arm. So, all right, let's get to the cross-examination. And all right, and I will be right back. I gotta take just a moment or two, but here, enjoy Mr. Lally for a few moments while I run to the
Now, you in conjunction
little
with,
place, and I will be right back.
I'm sorry, Dr. Wenchler, is that correct?
So I'll let this
Rensler,
run.
yes.
So you in conjunction with Dr.
Keep your voice up, Mr. Lally.
You in conjunction with Dr. Rensler and Dr. Klein wrote a report in regard to your analysis, correct?
Correct.
And doctor, that report was issued on February 12, 2024, is that correct?
Correct.
And in the first paragraph of that report, the last few sentences, you or whoever the author of that particular portion indicates, this analysis is based on information currently available to ARCA and is only to be issued in its entirety. However, ARCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
Correct.
And that's pretty standard as far as your industry is concerned. You can only work with the information that you're provided. Is that correct?
Certainly.
Now, in this instance, you were provided 10 things, and then there were 4 additional things that either you or the other doctors had reviewed as far as literature or things of that nature. Is that fair to say?
Correct.
And the 10 things that you were talking about were reports, an initial crime scene report, medical examiner dispatch removal report. Is that correct?
Correct.
Photographs of the incident location. Is that correct?
Correct.
And how many sets of photographs of the incident location were you provided with?
In terms of the number of photographs?
The number of photographs. Or were there different sets of photographs?
Yes.
And how many sets?
I don't recall off the top of my head. I know that there was a series that were taken during the daytime as well as ones taken what appeared to be in the early morning hours.
And you were also provided video from the early morning hours. Is that correct?
From what I recall, I think it was daytime, but yes.
Photographs of the vehicle, photographs of recovered evidence. Is that correct?
Correct.
CDR report from the 2021 Lexus LX570, correct?
Correct.
Autopsy report,
Yeah,
autopsy
into the
photographs, is
CDR
that correct?
report.
Correct.
And then some other things those would be the 10 things that you were provided with, and then there were 4 other things that you reviewed, or of course part of your team reviewed. Is that correct?
Correct.
Now, in regard to there's a section in your report called Review of Materials, and it talks about photographs and glass fragments and plastic fragments and things of that nature, correct?
Correct.
You also talk about a black drinking straw that was recovered on scene. Is that correct?
Correct.
However, there's no mention in the report about Mr. O'Keefe's shoe or Mr. O'Keefe's hat. Are you aware of those items as well?
Yes.
And are you aware that Mr. O'Keefe's shoe was actually found dug out from the snow, sort of flush with the curbing in front of the area where his body was found?
Yes.
Now, over the course of your work as a crash reconstructionist, and again, I don't mean this in any way, shape, or form, but I'm just curious. Typically, you're
curious.
reconstructing or you're looking at someone else's reconstruction in relation to something that occurred in the past, correct?
Not always, no.
Well, my question is, sir, how many times have you actually been on like a live scene where the vehicles are still in place at final rest, where there are bodies in place at final rest? Have you ever been to the scene where those sort of conditions existed?
Certainly. We have a rapid response team that essentially we've been on site on the day of or the week of the incident. Yes.
Now, how often is that?
Not nearly as often as, like I said earlier, we primarily do litigation work. So again, by the time we're retained, obviously the scene has been is no longer present.
Yeah,
Typically,
no,
you're
exactly.
sorry,
No
that's right.
answer.
That's mostly what you deal with.
No answers. Where all the blood was.
Correct.
You're correct.
And as
There's
far as
so
the
many
hat you're
things,
talking about,
so
of
many
course,
things.
You aware that was recovered as well, same day as the drinking straw on February 3rd in the area where the body of Mr. O'Keefe was discovered?
In the area of the front yard, yes.
Now, you have some familiarity through working as a crash reconstructionist with pedestrian collisions, correct?
Yeah, I'd heard that too, that when somebody's found, and in the cold, you can't pronounce them until they warm up because of the chance that they could could be resurrected, you know, and a lot of times it happens in drownings, right? Too, when somebody's
Is it
found
common or uncommon for
submerged
in the course of a pedestrian collision for a
in
shoe,
cold
glass,
water,
or hat,
though.
or something to fall off of that pedestrian?
They'll
in
wait
the
until
collision
they're
sequence
warmed
near where
up.
the area of impact occurs?
Well, I think that depends on the interaction between the two. If it's more of a side swipe type interaction, if we're just talking about an arm, for instance, contact the vehicle, no, I would not expect the shoe to come off. If it's something where the entire body is interacting with the vehicle, then yes, there's a greater likelihood that something like a shoe will come off. Yes.
So that is
I love
consistent in
it.
general
Turn the
terms with
Commonwealth
pedestrian
theory on
collision, the shoe
them.
coming off, correct?
Again, based on the interaction between the two. I wouldn't say it's a blanket statement that, again, in all pedestrian interactions, you will have a shoe come off.
And that's not the question I was asking. So what I'm asking is it generally consistent with pedestrian collisions that a shoe may come off during the collision sequence near the area of
And he
impact?
already said it depends.
Shoes can't come off in a pedestrian impact. Yes.
What? I mean, how does, if you're a juror and you hear, I mean, Lolly's just a dick. He's just a dick. What the hell?
Now, again, you were testifying
No,
about
no,
the,
you're
damage
correct.
to the
And
glass
they
being
won't.
isolated
I
in
mean,
the
I
area
don't
of the
think
tail,
normally
correct? And that was
EMTs
based on
don't
the information that you
pronounce.
were provided, correct?
Correct.
Now, with respect to any of the materials that you were provided, was there anything in the materials that you were provided that indicated that just the arm or outstretched arm of Mr. O'Keefe interacted with the vehicle?
No.
And based on your review of any of the materials that you were provided, was there any information stating that Mr. O'Keefe had been struck in the back of the head by the taillight assembly of the Lexus?
No.
And based on any of the materials,
The hell is
based
he
on any of the materials that
talking
you
about?
provided, were you aware that Mr. O'Keefe is on video exiting from a bar minutes before crash occurs at approximately 12:11 a.m. holding a cocktail glass in his right hand?
I'm not aware of that video.
What is he talking? Oh my God. Guy is such a putz.
Consistent with him throwing the glass at the taillight and breaking it, but not
Now, other
consistent
than the
with
material
getting
that
hit
we
in
just
the
went over,
arm.
as far as the 10 things that you were provided, you weren't provided anything else, is that correct?
That would be correct.
And so sort of the questions that you endeavored to answer, those were questions that you didn't know from any of the materials that you were provided, is that correct?
If I understand your question correctly, there was nothing in the material that indicated the questions we were to answer, if that's what your question was.
That is my question. So there was nothing in there, is that correct?
Correct.
Yeah,
Can I have a
there's
moment, Tom?
nothing in there. Nothing in there that you were. Nobody told you what to answer. You were supposed to come up with it yourself.
You talked a bit about, you have some extensive background in human factors, correct?
Correct.
And as far as visibility, and in particular, have you ever conducted a visibility analysis?
Yes,
Absolutely, 100%.
yes.
And you talked a little bit about conspicuity, is
I've
that
seen
correct?
those
Yes.
too. Those
Part
are
of
really cool.
conspicuity, at least one of the factors would be a reasonable expectation of, in particular, when you're talking
Yeah,
about
there's a lot of people that have put a lot of work into this and put out some very good things. I still don't know how you get 8 people to say that she was guilty of manslaughter. I just don't know.
would include sort of a reasonable expectation that a pedestrian would be in the path of the vehicle. Is that fair to say?
I don't understand your question.
When you're talking about conspicuity or visibility analysis, in particular, you're talking about.
Okay, so yeah, what was he asking? Let's go back because this was something Lolly did too. Is he asked questions that nobody could actually freaking answer.
In particular, when you're talking about a pedestrian, be a reasonable.
Yes.
And part of conspicuity, at least one of the factors, would be a reasonable expectation of, in particular, when you're talking about a pedestrian. Part of the conspicuity factors would include sort of a reasonable expectation that a pedestrian would be in the path of the vehicle. Is that fair to say?
I don't understand your question.
When you're talking about conspicuity or visibility analysis,
He's getting mad because the guy didn't understand what he was asking.
you're
Oh my
talking
God.
about something called PRT or perception reaction time, correct?
Well, that occurs after recognition. So first, a driver has to recognize that there's a pedestrian there before they can actually respond to it. So once they've recognized the pedestrian, then you start the perception response time where, again, the driver has identified what the hazard is. They're making a decision.
Yeah, no. And honestly, there are some people out there that think Bev's true. All right, I gotta go back and look here.
Then you start the pedestrian there before they can occurs after recognition. So first, a driver has
She's not paying attention to anything he's saying. She's just sitting there going, ah. But Yeah, no, that there are people out there that just think that if the state is going to bring charges, then they have to be guilty of something, right? There are people like that, and there are people like that on jurors, and that's what prosecutors are looking for. Somebody that's not going to question the state. I mean, it's just, and
To recognize that there's a pedestrian there before they can
that's who prosecutors want on juries.
actually respond.
Yeah,
to it. So
she's
once they've
intrigued.
recognized the pedestrian, then you start the perception response time where, again, the
Have you seen? You want to see my beach house?
driver has
I can't
identified
do
what
it.
the hazard is. They're making a decision about what to do. They might be moving their foot from the accelerator pedal to the brake pedal. So again, kind of that's the action.
Let's see. All right, there we go.
Something called PRT, or
Normal. Yep. Here we go.
perception reaction time, correct?
Well, that occurs after recognition. So first, a driver has to recognize that there's a pedestrian there before they can actually respond to it. So once they've recognized the pedestrian, then you start the perception response time where, again, the driver has identified what the hazard is. They're making a decision about what to do. They might be moving their foot from the accelerator pedal to the brake pedal. So
Yeah, right. I mean, but
again, kind of that's the
and then there was the statement too that they felt intimidated by, they said they felt intimidated by Higgins being there. Well, Higgins wasn't there. We know that. It was Albert, but still that was what they meant. That was intimidating to them too, to
action.
have the people that were the most contentious, the people that were, I mean, if we're going to do the third party culprit defense, those people were the third party culprits. So that is very
Where the time
intimidating
frame in
to
which
have
the
them
driver is
there,
undergoing
and they're all
action
from
to
the same
potentially
area.
mitigate the collision.
And perception reaction time, that's a pretty commonly used industry sort of standard as far as crash reconstruction goes, correct?
Well, I would say that it's used in the field of accident reconstruction, but as I mentioned earlier in my testimony, there isn't a blanket number in terms of perception response time. As I mentioned, it's based upon the hazard that the driver is presented with. Again, if you've got a pedestrian crossing the roadway, that's going to be one particular perception response time based upon studies and naturalistic data versus a driver suddenly stopping in front of you, right? It's not the same perception response time in every scenario.
No, understood. And there's different variables that may affect that as far as someone's age, as far as the lighting that's available, other things. Is that correct?
Sure.
And one of those things might be the reasonable expectation of a pedestrian being present in the roadway as you're driving along, correct?
Expectancy can play a role, yes.
Expectancy, what we're talking about, sort of the disparity or the difference between driving along a country road where there's no houses for miles and miles versus an urban area where there's crosswalks every 15 feet, correct?
Sure.
Now, in that expectation,
I did not. I saw the thing about the Kevin Albert and the fact that he's been suspended since, June the 6th or whatever that was. I was at work still, so I didn't get a chance to watch the meeting, but I'm planning on going back and watching that.
How high would that be if we're talking about a pedestrian that actually...
It's always interesting.
I don't understand your question.
Let me ask you this. If the operator of the vehicle has a passenger who then exits the vehicle and goes towards the back, would there be a high reasonable expectation that the pedestrian would be located in that area?
I don't know if I would classify it as high.
What would you classify it as?
Possible.
I honestly don't know that I have a classification to it.
Now, you never looked at the defendant's vehicle in this case, correct?
Correct.
Are you aware that the defendant's vehicle is still in police custody and available for inspection?
I'm not aware of that.
Did you ever ask to look at the defendant's vehicle?
No.
I mean, the tone, just Lolly's tone is just so dismissive. That's got to play on it as a juror too, right?
I'm not aware of that.
The defendant's vehicle in this case, correct?
Correct.
Are you aware that the defendant's vehicle is still in police custody and available for inspection?
I'm not aware of that.
Did you ever ask to look at the defendant's vehicle?
No.
Yeah, exactly. Condescension, just condescension the whole freaking time.
Now, it's typical pedestrian.
The same thing with that, with the doctor about the Boston Globe subscription thing. That was horrible.
Involves a pedestrian.
I mean, that was
in front of
just
the vehicle as it's coming down the street. Is that fair to say?
That was
That could be one
ridiculous.
type of interaction, yes.
Is that more prominently seen as far as your field than a rear collision?
I would say that's fair.
And there are various types of sort of interactions that the pedestrian can have with the vehicle in order to cause and sort of sustain injuries. Is that fair to say?
What I would say is that there's certainly, in terms of how the pedestrian interacts with the vehicle, in terms of whether they're being wrapped onto the vehicle or projected forward, certainly there's different types of interactions, yes.
So there's like a wrap and forward projection type of collision sequence. Is that correct?
Those are two common, yes.
There's also something called a fender vault. Is that correct?
Correct.
And sort of how or where that pedestrian is positioned
So-
in relation to the
You could tell that Lolly did a bunch of studying over the weekend as far as bringing out some of these.
vehicle is somehow
Some of these
somewhat
terms.
determinative of the injury sustained. Is that correct?
It can be, yes.
Obviously, you're going to see different injuries if someone fender vaults and goes over the top of the vehicle versus someone who is projected forward from the collision sequence with the front of the vehicle.
Just to clarify, again, in this matter, I was not assessing injuries. That was Dr. Rentschler. I don't have an opinion.
What I'm saying is based on your experience, so that you understand that there's a difference in the injuries that you might expect based on the type of interaction that a pedestrian has with the vehicle.
Condescending
And then
again.
if someone is
Yeah.
projected and the vehicle overruns that person, there'd be a whole other host
Yeah.
of injuries that you'd expect
Yes,
to see based on
Jeeves.
being
Yes.
overrun by the
Chat.
vehicle, correct?
There could be,
Chat GPT.
yes.
Now, the testing.
I
that you
like
did,
that.
with
Yes.
these are essentially experiments that you do, correct?
That's fair, yes.
And am I correct in saying that in scientific experiments or in the world of scientific experiments, there are certain things called variables that you're trying to account for? Is that correct?
I would say that's fair, yes.
And essentially what you're trying to do is control as many of those variables as you can in order to best replicate whatever the conditions were at the time that what you're testing to see actually occurred. Is that correct?
Correct.
Now,
Oh, is
what
this
anything
the
that you
wind?
do to control variables in relation to
The
temperature?
weather.
So one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees, that they'd reached a steady state temperature before we subjected them to the impact testing.
And where in your report does
She
it
made
say
him
that?
cold.
I don't believe that's explicitly stated.
Is it implicitly stated anywhere in your report?
But again, I'm telling you, that's part of what we did for the testing.
I understand that's what your testimony is, but you wrote a report, correct?
Right, and I don't know that I detailed every single part of the test. Again, we summarized it.
Understood. So what did you do to control any variable as far as wind?
Well, when you're talking about a projectile such as a glass, again, that's being projected at 37 miles per hour, again, there would be probably minimal effects in terms of the wind.
Even if there was a blizzard going on?
Again, what we're going after here is ultimately conducting.
It had just started snowing. That was the testimony that there was still grass. You could still see grass when they showed up at 34 Fairview. You could still see grass. The wind was not howling at that point. So
such that the drinking glass arrived at the location of the taillight. So if you're trying to say that, okay, he threw it this way and the wind blew it towards the taillight, sure, that could be a possibility.
And so I'm not trying to say anything. I'm just asking, are you aware that there was a blizzard and that there were wind gusts up to 37 miles per hour during the time that this collision
that is
occurred,
so
and that's not accounted for in
stupid.
the test?
That is
Were
so
you aware of that, sir?
I'm
freaking
aware that there was
stupid.
inclement weather at the time, yes.
Now, with respect to what type of glass did you use?
That is, I mean, oh, this part.
Used a
Okay.
large drinking glass, so that's a glass that has a thicker base.
All right. So we go from absurd to even more absurd
Sir?
because Lally is
I'm
a
aware that there was inclement weather at the time, yes.
Now, with respect to what type of glass did you use?
So we used a rocks drinking glass, so that's a glass that has a thicker base and a shallower sidewall.
And so what I'm asking, sir, was it cocktail glass, was it pint glass? What kind of drinking glass?
He
are we
just
talking?
told you it's a
A
rocks glass.
drinking glass.
And how tall is that rocks drinking glass that you use?
If I had to estimate, I think it was about 3 or 4 inches tall, probably.
And the thickness, did you measure that as far as the thickness of the bottom of the glass?
No.
Was the thickness of the bottom of the glass thicker or more thick or less thick than the top of the glass?
What does that even mean? I remember this from the trial. I remember this from when I was doing my other videos. What does that mean? Is the bottom of the glass more or less thick than the top of the glass? What? Every glass. Oh
Are you talking about this in comparison to the
God.
sidewall?
Sorry.
of the
Yeah, I
Talking
gotcha.
about in comparison to the side. So you have a glass, this rocks
I'm talking about in comparison with itself.
glass.
This
What's
makes
the
no
bottom
To it
thicker
now,
or the
sense.
He
top?
knows.
The sidewall would be taller, if you will, than the base.
And so when you're projecting this thing out of the device that you created,
This is absolute. How does the jury how do they
Whatever
even
it
take
was.
this guy seriously?
Are
And
you facing sort
I
of the
just
top of the glass
don't
where you would be
get
sipping
it.
out of, or the bottom of the glass at the tail?
So in the testing, the interaction between the taillight and the glasses was primarily between the base and the taillight.
Now, with reference to
yeah, because if you're going to, so you're holding a glass like this, if you're going to throw it, if you're going to throw it overhand, it's probably going to tumble, but you could also throw it this way, right? Like your arm could come, from to a side, basically like that. And so you would actually throw the, to be more of the base
video, and you weren't aware of Mr. O'Keefe
hitting
from
it.
the
So
waterfall bar at 12:11 in the morning, about 15, 20 minutes before he struck by a vehicle. You're not aware of that?
I'm not aware of that.
yeah, no, exactly.
Now, with
Absolutely.
reference to that particular establishment, was there anything stopping
Absolutely.
you or the other doctors that you were working with from going to that establishment, finding out what
I-
kind of glasses they had?
I absolutely
Outside
agree.
investigation.
I had
Why
no
didn't
idea
your
that video
police do
existed.
that?
Did you even know
Why
Mr.
didn't your
O'Keefe was
police
at a
do
bar
that?
before he was struck by the vehicle?
I believe that in one of the incident reports we reviewed that there was, I think, a narrative about that they had been at a bar drinking. Yes.
How is it that
I mean, thank you for
determined
reminding
where
us
on
that
the
your
taillight
cops could have done that.
assembly to aim?
So we looked at the fracture pattern and what it appeared to be that it was emanating from based
And I thought the fracture pattern part came out under direct, but I guess it came out under cross. This is an interesting
Basically where-
part too, I
Assembly
think.
to aim.
This is it. And I don't know if it's interesting
So
to
we
the
looked at
jury
fracture
or not,
pattern
but
and what it appeared to be that it was emanating from basically where the clear portion meets the red cover. We kind of saw that
Yeah.
the fracture
Yeah.
pattern emanated from that. So that's where we targeted it.
Now, when
that's that's another reason why they thought this is because they saw that fracture pattern and they were able
you did
to
this testing as far as
duplicate
the
it.
sort of breakage or the pieces that came off the taillight. Is it fair to say that they were of sort of different shapes and sizes, the broken pieces,
Sure.
consistent with the broken pieces that were found on the scene near Mr. O'Keefe's body?
Yes, I would say that's fair.
Now, I know you may not be the person for this, but just as far as your reviewed some of the autopsy report, medical findings in regard to Mr. O'Keefe, correct?
Correct.
And the injuries to Mr. O'Keefe were primarily on the right side of his body, correct?
Correct.
Were there injuries to his right arm and forearm, elbow area, correct?
Correct.
There was bruising to his right hand, do you recall that?
Yes.
There was an abrasion to the outside or the posterior of his right leg near his knee, do you recall that?
I don't know that I recall that off the top of my head.
And do you recall sort of the skull fracture or the laceration that immediately outside of the skull fracture was on sort of the right back of his head?
Yes.
Now,
And
from
so
the
what?
reports that you reviewed, were you aware that when Mr. O'Keefe's body was discovered by the defendant and two of Mr. O'Keefe's friends, that the defendant was the only one who could see him in the conditions?
Objection.
Sustained.
As far as the lighting was concerned in that area where Mr. O'Keefe's body was found, are you aware there was no overhead street ambient lighting or anything like that?
Objection.
I'll allow that.
I'm not aware of that.
And you didn't do any visibility analysis or anything in relation to this case, correct?
That wasn't a part of my scope in this case.
Well, as far as part of your scope, did you define that you indicated earlier that there were questions that you didn't find in the materials that you had to
Oh,
conduct
that's
experiments
cool.
to prove or disprove, correct?
Well,
We have Australian
the entity
shepherds.
that retained us in this asked us to evaluate whether or not the damage to the vehicle and the injuries to Mr. O'Keefe were consistent with the interaction or in interaction between the two.
So you were at least somewhat restricted in the scope of what you could do based on the parameters given to you by the agency to hire. Is that fair to say?
Sure.
Yes, they didn't.
Okay, so just
Between the two. And the injuries retained us in this asked us to, well, again, the entity that retained us in this asked us to evaluate whether or not the damage to the vehicle and the injuries to Mr. O'Keefe were consistent with the interaction or in interaction between the two.
So you were at least somewhat restricted in the scope of what you could do based on the parameters given to you by the agency that hired you. Is that fair to say?
Sure.
so that could
Yes,
have
they
been
didn't
that could have been an effective question right there. That they were limited in their scope. So I mean, just looking for anything that the jury could take
a
from
blank
this
check.
and still come up with it. They met their burden of beyond a reasonable doubt. I don't.
Now, as far as any statements by the defendant to investigating troopers either that afternoon or that morning when Mr. O'Keefe's body was discovered, were you familiar with any of those?
Objection.
I'll allow that.
I'm not
How is that relevant to the
familiar with.
right here? That question right there that was allowed. Right there. You are correct. She allowed that question. It has nothing to do at all with the case, the trial, nothing.
Then
That had
They
the
do
case
a lot
of the
of
trial.
civil
It had nothing to do with these experts' testimony. What she said, her, I hit him.
litigation.
Nothing to do with
Be
this.
drawing from
The long one, I
As it
think.
To the def-
Okay.
published wind gusts up to 37 miles an hour.
So, doctor, with regard to the defendant's statements at any point where you
And she let it go. She's letting it in.
materials or were you made aware?
She's letting it
the
in.
defendant said to multiple people on scene, I hit him, I hit him, I hit him, I hit him.
I'm not aware of that.
Okay, so there again, he said it 4 times when nobody has ever said that she said that 4 times. He has to exaggerate every single thing. Little pink faced.
Can I have a moment, John?
Yes.
Yeah. This guy just irritates me to no end.
Now, within the reports that you and the other doctors submitted, there's an indication that if either Mr. O'Keefe's arm or head had interacted with the taillight, there'd be some expectation that either blood or DNA would be contained on that taillight. Is that correct?
I believe yes.
It
that's
was
in the report.
touch DNA.
And
It
at any
wasn't
point were you
blood
aware that Mr.
DNA.
O'Keefe's DNA actually was recovered from that taillight assembly from the defendant's vehicle.
No, I was not.
Okay, but this could, potentially
As far
that's.
as forensic reports, what, if anything, were you provided in reference to that, other than the initial crime scene?
The jurors got to take that into consideration, I guess.
Report?
Are you talking about specific to the scene or forensic reports to the body?
Forensic reports specific to the evidence that was recovered from the scene and from the defendant's vehicle.
Only what would be listed in the report.
Why is he so condescending all the time? Why does he have to be so condescending? I just don't. There's no reason.
Now, you indicated one of the materials that you were provided and you reviewed was the EDR, event data recorded data.
The crash data retrieval report, yes.
Now, were you shown anything as far as a crash reconstruction report from a trooper from the state police?
No,
And the EDR data that you observed, did that contain any sort of usable data?
there was no events recovered on the black box.
And with respect to there being no events recovered on the EDR or the black box in a pedestrian collision, is that unusual?
It is not.
And why not?
Well, because you're talking about, a very large weight difference between the vehicle and the pedestrian. So ultimately, what the vehicle is constantly monitoring is acceleration, which gets back to
Maybe
the
there's
term called
no-
delta V. So when the vehicle doesn't experience a big delta
Maybe there's no data on there because you guys screwed it up.
V, typically the threshold for a non-deployment event where you're not firing airbags or any safety mechanisms, but the vehicle wakes up and says, hey, there was something that I potentially hit. And it's usually at a threshold of about 5 miles per hour. So again, given the weight difference, we usually don't see delta Vs that high with pedestrians.
And is that in some respects because what EDR and what the safety restraint systems are designed to protect is the occupants of the vehicle, correct?
That's fair, yes.
I mean, there are more innovations as far as vehicles that are more modern or released earlier that have certain pedestrian or protections for other vehicles, but primarily what they're focused on is the occupants of the vehicle, correct?
Correct.
Now, at any point in time, were you shown any texturing data, Toyota texturing data from the defendant's vehicle?
No.
So you weren't shown any data indicating that the defendant's vehicle was being operated in reverse.
The objection sustained. Next question.
Yep.
So with regard to the defendant's statements, were you also not told that the defendant told several people that she had just gotten into a fight with Mr. O'Keefe right before she dropped him off on 34 Fairview Road?
So that's sustained.
What does that have to do with the
Doesn't
evidence
change the mechanics,
and
Mr.
the?
Lally. It doesn't
Thank
matter
you.
if she thought she hit him or if they got in a fight.
Andrea.
Or even if she wanted to kill
You're
him.
correct.
Doesn't change the mechanics.
Center of mass.
Yes.
And what kind of role does the center of mass for a pedestrian play in relation to center of mass of a vehicle as far as how the two interact?
Well, it depends again on the vehicle structure. And again, when you're talking about where's the hood height, the bumper height,
Yeah.
CG or the center of gravity of the pedestrian, that again will kind of dictate how they interact with between the vehicle and the pedestrian.
Now, typically, a typical pedestrian collision, again, that we were speaking about before, is in relation to a pedestrian struck by the front of the vehicle, correct?
Correct.
And so in a typical pedestrian collision, that involves more of an assumption of the velocity of the striking vehicle than you would see occur in sort of a side swipe. Is that correct?
I'm sorry, can you repeat the question?
In a typical pedestrian collision, that would involve more of an assumption of the velocity of the striking vehicle by the pedestrian than you would see in a typical side swipe collision. Is that correct?
If I understand your question correctly, yes. If the vehicle is striking
If I understand you ask stupid questions, Lolly.
the center of gravity of
You
the
ask
pedestrian as opposed to
stupid
just, for instance, a
questions.
limb, yes, the center of gravity of the body will be accelerated up to that speed.
Now, with respect to the defendant's vehicle, again, you never actually looked at the defendant's vehicle, is that correct?
It wasn't necessary.
And did you look at the actual taillight housing from the defendant's vehicle?
I had sufficient photographs of the taillight.
Did you ever
Wasn't
look at the actual
necessary.
physical broken pieces of the taillight from the defendant's vehicle?
Again, I had sufficient photographs that documented the fragments and pieced them together.
And you're aware, at least, that the fragments that were recovered on scene were then sort of put back together and put overlaid over the taillight housing that was taken from the defendant's vehicle?
Yes.
And through any of the pictures of the photos
Welcome back.
that you observed, did you ever see a piece of metal protruding underneath the broken and shattered plastic pieces from the taillight?
I believe it was a plastic chrome piece.
And when you were doing the testing as far as shooting the glass, the drinking glass at the taillight assembly, that taillight assembly was sort of held there by vice grips or something like that, is that correct? It wasn't actually physically attached to a vehicle that you were shooting at?
That's correct.
Yeah, no, exactly. It's just
Now, as far as that, you're familiar with, there was a piece of a broken drinking glass that was recovered from the same area where Mr. O'Keefe was found, is that correct?
Amongst the fragments of the taillight, yes.
And are you familiar with Mr. O'Keefe's DNA being present on those pieces of the exterior of a broken drinking
so
glass?
he
located-
held the.
I don't believe so.
So if he was holding the drinking glass, wouldn't his DNA be?
Now, as far
that
as Mr.
matters.
O'Keefe's clothing, his fingernails,
Yeah.
there was DNA of Mr. O'Keefe and no one else recovered from both his fingernails and from a variety of areas of clothing.
Objections. So beyond the
Sustained.
scope.
What? My God.
Now, from the crime scene reports that you reviewed, are you aware that there was human hair that was located on the right rear
You already
and
asked
near the
this.
tent you were
Objection.
talking about?
Objection.
I'll allow that.
Yes.
It's
Are
asked
you
and
familiar,
answered.
are you
Bev.
aware that subsequent mitochondrial DNA
Correct.
testing found that the mitochondrial DNA profile for that hair was consistent to a probability of 99.895% with the mitochondrial DNA profile of Mr. O'Keefe?
I'm not aware of that.
What does that matter? One
I mean, just keep
stupid
hammering that
hair.
number,
Now, were you
Lolly.
also aware that the
because
broken
it's
drinking glass with
300,000
Mr.
people
O'Keefe's DNA on it was
that would
found
match
to be
it.
consistent with broken drinking glass pieces that were found in the street?
Objection.
I'll allow that.
Can you repeat the question?
Were you aware
What?
that the pieces from the exterior of the broken drinking glass found near Mr. O'Keefe's body with his DNA on it were then found to be consistent with pieces of broken drinking glass that were located in the street of 34 Fairview Road?
Yes.
And not the bumper sprinkles. Did you know the
Were you
bumper
also aware that
sprinkles were
pieces of
not
glass that
consistent?
you're talking about from the defendant's bumper were found to be consistent with pieces of glass recovered from the street in front of 34 Fairview Road?
Yes.
Were you aware that there were microscopic
They were not. What? He just.
pieces of red and clear plastic, about a 16th of an inch by a 16th of an inch, that were recovered from Mr. O'Keefe's clothing that were then found to be consistent with the tail?
One piece that is. Oh, God.
No, I don't believe so.
I'm not even. Microscopic is not 1/16th by 1.
Now, as far as, again, you weren't provided with any sort of
Oh, this
reconstruction
guy.
report from a trooper Paul from the state police?
No, I was not.
You're not aware that he took measurements from the ground to where certain items were on the vehicle?
Objection.
The objection sustained. He didn't see the report. Sure.
He just keeps doing it. Lolly keeps doing it. He knows what the limitations are. And he keeps doing it
Look
anyway.
how pink he is. Look at that pink idiot.
Unmuted. Yes.
You can't ask those kinds of questions. Does he have anything left?
I mean, I am not impressed with. There's a lot I'm not impressed with the
My apologies. I was just,
Commonwealth of
Yes.
Massachusetts and its inhabitants. I'm sorry. Just there's a lot that,
now, doctor,
yeah.
in the course of your
A lot to
analysis,
not
your
be
materials
impressed
here,
about.
were you ever-
and if there's 8 jurors on this jury that thought that the state met their burden of beyond a reasonable doubt, that makes me question and just even more.
provided with a video of the defendant backing out of a garage and making contact
Yeah.
with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th?
No.
The solo cups were consistent with the cups held by the.
No,
Yeah.
thanks for reminding us
Your
that
doing the
happened.
testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that
Oh my God.
create the damage to the taillight that you observed in this particular case?
At that speed, no.
Could have cracked it though, couldn't it have? Could have cracked the tail light. Absolutely.
You said 37 miles an hour was what it took for the glass to create that kind of damage.
Then we can do our 2 o'clock.
Bev's over there whispering about her daily schedule.
Yeah, she is.
So There were about 10 items that you were provided that you reviewed. Is that correct?
Good Lord.
And a number of different items.
He
that statute
answered
about that you weren't
this.
provided with or you weren't aware of, correct?
Correct.
And again, in your report, in the very first paragraph, you indicate, however, ARCA reserves the right to supplement or revise this report if additional information becomes available, correct?
Correct.
Yes,
I have nothing further.
All right, Mr. Jackson.
Thank
you are correct.
Very briefly, Dr. Wolf, you were asked on cross-examination a couple of questions about hair, DNA on the outside of the taillight lens, I'm sorry, the taillight housing, and glass material. You recall that?
Yes.
Does any of that change your opinion about your opinions and conclusions in this case?
Objection.
I'll allow that.
Absolutely not.
Absolutely not.
What is your conclusion as to whether or not the damage
Yeah.
to the vehicle and
No,
the injuries to the
exactly.
human being are consistent?
Exactly. Lolly does not have, he absolutely does not have the acuity, the mental. Yeah, he's trying to go toe to toe with this guy, and it's just not gonna happen. Sorry, buddy, you're outmatched
Inconsistent with the vehicle
in
interaction.
a game of wits. You have
All
no
right, Dr. Wolf,
racket.
You are all set, sir.
Thank you.
You all set, sir. 45 minutes
You-
to lunch. We're going to get well into Dr. Rentschler. We're getting done today, guys.
Ugh.
It's going to happen.
All right, so we got
It's going to happen. That's my
Dr.
bed.
Rentschler.
I've been with ARCA for about 16 and a half years now.
You indicated that your
All right,
position
let's
as
see his
functions.
name.
And could you
EHL.
first and last name, spelling your last name for the record?
Certainly.
go.
Andrew Rentschler, Rentschler.
And what do you do for a
Forgot the
living?
T.
I'm a biomechanical engineer and accident reconstructionist.
And who do you work for?
I work for a company called ARCA LLC.
How long have you been in that position as the, working for ARCA? First of all?
I've been with ARCA for about 16 and a half years now.
You indicated that you're the director of biomechanics and human factors. Is that right?
I am. I'm a vice president and the director of biomechanics for the Midwest Division.
Can you tell us what
VP.
education, training, and background qualifies you to perform your duties as the director for biomechanics and human factors?
Sure. Well, I've got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanical engineering from the University of Pittsburgh in 2002. And
He's a
then I went to get
Pittsburgh
my
guy.
doctorate for my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Doctor, do you specialize in research and analysis to evaluate specifically the study of the relationships between crash injuries and crash forces?
I do, yes, sir.
And when I
He
say
got a
crash
haircut.
injuries, we're talking about to human beings.
That's right. Injuries to human beings, whether it be in a crash, motor vehicle accident, slip and fall, industrial, any type of setting where there's an injury to the human body. I evaluate basically that event and the mechanisms responsible for producing those types of
So
injuries.
here we go.
Doctor, does
We've
it also
got.
include the study of and understanding
Yeah.
of human kinematics?
It does.
I know. I mean, I don't know how. I mean, this testimony is so. It's just so. I mean, it's
Yes.
As well as human tolerance.
it had to have very strong weight, you would think, with the. Yeah, I mean, right. If I mean, we talked about that earlier when, they talked about agencies, Jackson did use the word agency. And
We
so
all know what tolerances mean. What is
you-
kinematics?
when you hear the word agency, you think, was this a government thing? And so, but he makes a point that neither of these people hired him. They know that there was
So
an
kinematics is
outside
just
the outside investigation thing came out multiple times. Multiple witnesses were asked about their testimony to this other, can't remember exactly the word they used, but they're, when they talked about the federal grand jury, they didn't say grand jury, but they said this other, you gave testimony in this other, can't think of the term, this other
Motion of
event.
the human body. And it's the study of the human
basically,
body, how the body
so-
moves under different circumstances.
Yeah,
You're in a
no,
car and it's
he
struck
did. He did. At the very beginning, he said, we have never met. I have never asked you any questions about this. And
behind,
so
what direction will your body move?
he might do
slip
it
and fall,
with
how will your body rotate and
Rentschler
move.
too
It's really
here.
looking at the motion and the response of the body.
Are you
Yeah,
certified
when
by
you
any professional
when you
association?
I have again, a PhD. There's no
when
professional.
you hear
licensure for,
agency, you think of a
biomechanical
government
engineering. It's the
agency.
highest, basically
Absolutely.
certification you can get. And I'm also a member of SAE, Society of Automotive Engineers, as well as the American Society for Mechanical Engineers.
Have you received additional training and education in further beyond your PhD and the associations that we just talked about?
I have, yes, sir.
Can you describe, without going through all the detail, describe the kind of continuing education that you engage in?
Well, I
Right.
take seminars.
The
and
Men in
professional
Black,
classes
yeah.
with respect to biomechanics as well as action reconstruction. But looking at
Exactly.
new technology and research with respect to injuries.
Could
For instance,
this
motor
have been
vehicle
an
accidents,
alien?
There's new safety measures such as airbags, seatbelt pretensioners, auto detection devices on vehicles. So it's really kind of staying up to date with the current research and literature that's out there.
So your specialty, your subfield, if you will, in terms of your engineering degree and education is literally in accident reconstruction and the effect that accidents and incidents can have on the human body. Is that right?
It is, yes. And biomechanics is really, it's looking at injury to the human body. So, we use traditional engineering principles and apply it to the body because an injury is just an engineering problem. Instead of looking at a piece of steel that if you know the dimensions and size and you apply a force, it'll bend and break.
Exactly.
We look at the human body. How much force does it take and how does the force have to be applied to get a humerus fracture or intervertebral disc injury or any type of injury? There's specific forces and mechanisms you need to produce those injuries. And that's what I do as a biomechanical engineer.
Is there a difference between a biomechanical engineer and a doctor?
There is, yes.
In terms of visions?
Yes.
Tell us about that.
So we really approach injuries from two different directions. Someone has an injury, you go to the doctor, you go to the hospital, the medical doctor will diagnose that injury, determine the best way to treat it, and determine what the prognosis is. As a biomechanical engineer, I look at that injury from a different direction. Here's the injury. Well, how did that injury occur? What type of loading did you need to actually produce that injury? How much force was required? What happened to your body to actually cause that injury to occur? So we approach it really kind of from two different areas. And certainly the doctors diagnose the injuries and determine what they are, and then the biomechanical engineer will come in and we'll look at that injury. And not only how's it produced, but ultimately our hope is to mitigate and prevent injuries from occurring, whether in motor vehicle accidents, sports settings, industrial settings, anywhere there's interaction with the body and the environment, we want to try and make it safer for individuals.
So you're not
I never saw, I mean, there was a couple little things in Lolly's cross-examination of Dr. Wolf, just thinking about it before we move on with Dr. Renshaw here very far. A couple small things, like, you were limited in the scope of what you could do, but it should have blown their entire theory out of the water that he was hit by a car. It just should have.
as much as you are trying to
Their
figure out the
testimony
mechanics, the
should have.
forces behind the injury. Is that right?
That's right. I'm not a medical doctor. I wouldn't
There was-
diagnose an injury, but
There was already reasonable doubt in this thing, and these guys completely just blew the rest of it out of the water.
given an injury, I
Absolutely
understand the
should have.
mechanics of how that injury is produced
Yeah.
and what you need to actually cause that injury to happen.
Are you also published in the
distinction.
field of biomechanics?
You're
or engineering?
correct. They
I am.
could have. They absolutely could have used
When
these
I
guys.
did my graduate work at the University of Pittsburgh. We worked
But that they wouldn't. Their theory was their theory, and these guys would have
I worked at a
blown
place
their
called
theory out of the
Engineering
water.
Research Lab, and it was associated with the VA in Pittsburgh as well as the
Cow and
University of Pittsburgh.
pirouettes.
And so we looked at people with
Yes.
disabilities. Well, one of the big things that we did, one of the major points was people in wheelchairs.
I love
so
it.
If you have to propel a manual wheelchair, you put a lot of stress and force on the arm, the shoulder, the elbow, the hands, carpal tunnel. So we look at the injuries that are produced during those types of events.
Yes.
How can we reduce the
Stuff.
force acting on the body for someone like that? So it's looking at, again, how the body responds, how we can set up a chair differently to actually reduce the amount of force someone might experience doing that type of an activity.
Or
Qualified as an expert.
you were told about it. Who told you? The crime scene told me.
In the past in the area of biomechanical engineering and human factors.
I have, yes.
The crime scene. The crime scene told
in
you?
furtherance of-
Yes.
Let me ask it this way. Were you asked to engage in an analysis?
Crime
on
scene
the-
tell you anything else?
Of the incident that is currently before the court.
I was, yes, sir.
Did you
Unbelievable.
produce, or did your team produce a report about your opinions and conclusions, including the testing and the methodology that went behind those?
Yes, exactly.
You were not hired by
The
the defense in
crime
this case,
scene
correct?
No, we were
whisperer.
You were not hired by the Commonwealth in this case.
That's correct.
Here we go again.
Started your
Here we go
analysis.
again. Okay. All right. Right here. I'm going to go slow this down. He reiterates it again for the
Opinions and
jury.
conclusions, including the testing and the methodology that went behind those opinions and conclusions.
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were
Right
not hired
here.
by the Commonwealth in this case.
That's correct. We were not.
When you started your analysis, you didn't know who we were. You did not know who the Commonwealth was.
That's correct.
You'd never heard of the Karen Reed case.
I had not. No, sir.
You were contacted by my office after you provided your report, correct?
That is correct. Yes.
Were you ever contacted by the Commonwealth?
Not that I'm aware of. No, sir.
Right?
And you and I never discussed the substance of your testimony, correct?
That's correct. We have not.
Never discussed it. There it is. There it is, right there.
Would you consider that your analyses, your conclusions and opinions in this case are completely independent of any party in this room?
Objection.
Sustained.
What?
You've not been paid by the
Leading.
defense, is that right?
I
Yeah,
have
I
not.
guess.
No, sir.
And you do not answer to us in any way.
I do not. That's correct.
You indicated that you and your team were asked to undertake a
All right.
review of the
Back up a
circumstances.
little bit.
What exactly
Okay.
did you review? in coming to your opinions and conclusions and performing the tests that you performed?
Well, we looked at, there was police reports with respect to the incident, medical records for Mr. O'Keefe, as well as the autopsy report,
Yeah.
photographs of the evidence in this case involving the Lexus, the tail light, the incident scene where the evidence was found, as well as some other documentation.
And you also worked with Dr. Wolf, who just left the courtroom, correct?
I did, yes.
Did you two have sort of a distinct role in, although working as a team, a distinct role in making determinations and conclusions about the incident?
That we did. There was a distinction. Certainly some of our work overlap, but there was a distinction with what each of us actually did and performed with respect to this case.
Following your review and your investigation and analysis, did you make any determination as to whether any of the injuries suffered by Mr. O'Keefe in this case were consistent with producing the damage that was seen on the SUV?
I did, yes, sir.
And what did you base your opinion on?
My opinion was based on certainly the medical records, the description of what the injuries were.
Yes,
the
the
damage
cannon.
that we have to the Lexus, primarily the right rear tail light cover, as well as we performed testing to evaluate the strength of that tail light cover and look at the damage associated with different types of impacts, and also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So did you look specifically to find whether or not you could determine the forces required for Mr. O'Keefe to suffer the injuries that you saw in the records, medical records, et cetera?
I did, yes. I determined in my analysis whether there was sufficient force with that damaged taillight and interaction with that taillight to produce any of the injuries that were listed or diagnosed in the autopsy report and the medical records.
What, generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
I'll allow that, just generally.
Good.
Dr. if you would, please.
Yes, Your Honor.
Yeah.
So 24 miles an hour, once you get up to that speed, you
Absolutely
start to see fractures.
do
You see
that.
significant ligament and tendon damage. I mean, usually
Allow
15
that.
miles an hour, 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact the vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part of your body.
At 15 miles per hour, not 24 miles per hour, like, which there's issues with that anyway, but at 15 miles per hour, this happens.
Impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur.
Is that true for
Yes.
any part of the body that is struck, whether it's center mass or an extremity? 1,000 pounds of force the speed of the vehicle.
Oh,
So
yes.
force
Oh,
is
that would be
equal to-
awesome.
Second law of force is equal to mass times acceleration. So the acceleration is going to be the same. It depends on the mass of whatever body part's being hit. So from the testing that we did at 15 miles an hour, we used a head form, which weighs about 11 pounds. And that produced almost
Yeah,
1,000
exactly. A
pounds of
big
force,
old
little under
pink-
that for the head. So
big
anything
old
that weighs
pink
11
target.
pounds is going to produce almost 1,000 pounds of force. The heavier the object, if you get hit center mass, that's going to be even greater force because that's more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body.
Did you review, in furtherance of your conclusions and opinions, did you review records that indicated injuries to both a head as well as an arm, the right extremity, right arm?
I did, yes, sir.
Taking those one at a time, is the injury to the head that you saw consistent with having been struck by a vehicle at 24 miles per hour?
It is not, no, sir.
Can you explain why that is?
There's a couple of reasons. First of all, and the main reason is that to get the injury, it was a fracture at the occipital region of the head, which is basically on the back bottom part of the head. So in order to have that part of the head contacted by the tail light, you would somehow have to have a configuration or be standing in a manner that the rest of your body doesn't get hit because there's no other significant injuries to the body. If there's enough force to cause a skull
What, if anything, would you throw at that board?
fracture, then there's going to be certainly enough force to cause injury to the rest of the body. So first of all, you have to determine how could you configure somebody could actually be standing
Who, if anyone, would you invite to your party to throw things at that board?
to have only the head impacted, the back of the head. And even if that was the case, if somebody positioned themselves in such a manner to have that occur, you're still going to see other injuries related to that. For instance, with the cervical spine, over 1,000 pounds of force acting on the head, you're going to get significant cervical injuries, fractures, disc injuries, tendon and ligament injuries. So the fact that we only have that head injury and only damage to the occipital portion of the skull is inconsistent in this case with being struck by that tail light. And then there's also the evidence that we saw when we did the testing. At 15 miles an hour, where we dropped the head form, so that would be akin or like a vehicle backing up at 15 miles an hour hitting the head. We had more damage to the tail light in that test than what we saw with the subject tail light cover. So if you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear tail light. And we just don't have that in this case. So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus.
Shifting to the arm, are the same forces at play if instead of the head making contact with the tail light, it's an outstretched arm, for instance, at the elbow area of a human being, the person 73 inches tall, weighing 215 pounds?
Objection.
The objection sustained. Ask it differently.
Sure. Shifting to the arm, are the same forces at play?
Were you aware
if
of his
instead making
dimensions?
Contact with the head, you make contact with the arm, outstretched arm.
They are. I just explained the force is mass times acceleration. So if the arm weighs the same as the head, you're still
Yes, it would. kind of look like this. Hey. Okay. Only with a, yeah, I could see it. I could see it. Put it right there. I'm gonna have to work on that.
Going to get that same force. On the
Photoshop.
It does actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. So your arm, basically your whole arm, is about the same, weighs the same as your head.
So is your analysis the same then if the arm, close to a 1 pound arm, made contact with the taillight traveling 24 miles an hour, sorry, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that taillight, you're going to get even
oh my gosh,
more
yeah, the
significant
weeble wobble
damage
bag,
at
yeah.
higher speed than what we saw.
So was the taillight damage consistent?
Big old pink-faced one.
It was, our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay. I want
What
to
other
shift back
reasons?
to
So their theory is he got hit by the arm, and that's what did it. And they just obliterated that completely.
head injury that you saw.
So
Was the head injury that you saw?
you have to take the prosecution's theory. You have to take their theory. That's what the jury has to go on. And this is absolute reasonable doubt that he was hit by that car.
Consistent.
Absolutely.
Backward from a standing position on the rigid surface.
That's certainly one of the possible scenarios that would create the injury mechanism. You fall backwards, strike your head on concrete. That can produce thousands of pounds of force on the head. And so that's certainly a scenario where you could produce that damage if someone was standing, they fell backwards and struck their head on the roadway or on the curb or a hard surface.
So I was going to ask, if you think you may just answer my question, that kind
Yeah.
of force multipliers require a hard rigid surface or not?
They do, yes, sir.
So grass and dirt would not produce the same sort of force.
At 24 miles an
That would
hour.
certainly not produce the same amount of force as hitting your head on concrete.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more so.
What injuries?
So again, the second part that he got thrown and hit his head, they have completely
I want to shift back to the
obliterated
arm. I wanna go back
that
and forth. Bear
too.
with me. Talking about the arm, if presuming a strike at say 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You can
Right
see
here.
significant damage on the arm, especially if it hits at that taillight. Enough force to actually cause fracture of that taillight. That force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous lacerations, bruising, contusions. You're going to see most likely fracture of the arm as well. You're going to see significant damage. Just imagine having your arm out and being struck by a car at 25 miles an hour. There's going to be significant damage, more so compared to simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs of the arm in this case, of the John O'Keefe's arm in this case, right?
I did, yes, sir.
All right. Were the injuries that you saw on John O'Keefe's right arm consistent with having been struck by a vehicle in the manner that you just described?
Objection.
That's sustained, Mr. Jackson.
Why not?
You reviewed injuries specific to John O'Keefe, correct?
I did, yes.
Taking that as a hypothetical, would the injuries that you saw, generally speaking, hypothetically be consistent or inconsistent with having been struck by a car at 24 miles an hour?
Objection.
Sustained.
A reproach?
Yes.
There's nothing wrong
How
with these
is this
questions.
not allowed?
He doesn't have to state it as a hypothetical. He evaluated this precise case, these actual injuries. And if he's an expert to be able to opine about injury causation, then yes, he gets to opine
Correct.
about the causation of these injuries.
Absolutely does.
About 4 minutes.
How long is this one? This one takes a while, I think. Okay, here we go.
Foundation.
If you were to presume, for purposes of my question, that an
Oh my
arm
God.
was struck by a vehicle, taillight traveling at 24 miles an hour or thereabouts, would you expect to see patterned abrasions with no bruising?
Objection.
Or just what would you expect to see?
What would you expect to see?
So again, I would expect to see significant trauma to the skin,
my
to the
God.
bone, to the tendons. I wouldn't expect to see just abrasions.
See
pattern
their
abrasions.
feet,
An
yeah.
abrasion, by very definition, means that it's trauma to the skin, which is created through rubbing or grinding or friction. So it's basically something rubbing against the skin that basically wears away that top layer of skin. It's not blunt force trauma. If you have blunt force trauma, that produces a contusion or a bruising. It's not a laceration type injury where you have a cutting injury that actually produces a cut or a significant laceration. It's really just rubbing along the skin. So that would be inconsistent. If you have an arm that's actually struck at 25 miles an hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracturing of the taillight, then parts of that taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. We don't.
And Lolly likes to talk about his microscopic piece of 1/16 inch by 1/16 inch. You're going to have a lot more than that in that arm if that's actually what happened.
Basically just superficial abrasions, which all appear to have a similar amount of force. There's not a difference. That's the other thing. If you had a taillight shatter and explode on an arm,
right here,
some areas where you would have very deep contusions or lacerations, others lighter areas. But when you look at the abrasions that were noted in this case, they all appear to be the same force, generally the same direction, and the same severity, which would be inconsistent, in my opinion, with being struck at 25 miles an hour.
Generally speaking, you look for consistency in size of an object striking a body and the injury that the body suffers from being struck by the object.
Absolutely. I mean, size is a big part of it, certainly. Yes.
Did you do any measurements of the size of the taillight, the width of the taillight that was shattered?
Yes.
And what was that width?
I think the width we looked at was maybe 6 inches or so.
In review of your, in coming to your opinions and conclusions, did you look at the arm of John O'Keefe just sort of laid out, straight out?
I did, yes, sir.
Did you see where the injury started and stopped, or began and ended, however you want to put it, in terms of size?
Yes, I mean, it started from the upper arm and then extended into the forearm, which was greater than 12 inches of.
He loves to repeat those two things.
Of length, where you see those injuries and those abrasions occur.
Did you come to any conclusions or opinions concerning the size differential between the taillight and the injuries that you see?
Objection.
Sustained.
Generally speaking, would you expect if there was an injuring event that the size of the injury would be consistent with the thing that produced the injury?
Yes, generally
Here
speaking,
come
you
the
would certainly expect
sirens.
that. And again, you would normally and usually be able to see an initial point of contact because that's where the most force is going to occur, where it causes that taillight to break. So you would have an area of severe damage, and then it would extend out likely to the edges of where it would contact the rest of the taillight.
From a biomechanics and or a physics standpoint, engineering standpoint, is it reasonable if someone is standing with their arm extended to be hit by a moving vehicle at say 25 miles an hour, and the center mass of the body to be projected?
Objection.
Ask it differently.
Is it consistent in your view with engineering principles and physics principles that you know? An arm is hit, extended, not the body, just the arm is struck, for the body then to be projected?
Objection.
I'll allow that.
It's not, no. So if we have contact, your arm's down, we have contact to the arm. I mean, first of all, it's just a ball and socket joint, so the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm. But secondly, it all depends on your center of mass. The center of mass is kind of the equilibrium point of your body.
You got that pig DNA.
And for most normal people, the center of mass occurs at your umbilicus or your belly button. So wherever your belly button goes, that's where your body's going to move. They teach this to football players, right? If you're a defensive back and a running back comes around the corner and it's you against him, they tell them or they teach them to watch the waist and watch the belly button. It doesn't matter what your head or your arms do or what their feet do. Wherever their belly button goes, that's where they're going to go. So that's what you want to tackle.
You watch the center.
Even if you had your arm straight out, again, we said it would move because of the joint. But let's assume you.
That's what I'm trying to. Yeah, that's what I'm trying to understand. I'm trying to understand how eight jurors can still consider her guilty of manslaughter. Which means she hit him. I mean, that's what they're saying. That's what 8 jurors have said.
Around, right? Because it's producing a moment arm, which produces a torque on the body. So your body's
it's so perplexing.
In order to get that body, or the complete body, over, for instance, 10, 20, 30 feet into the yard, you need a force acting at the center of mass. You need an external force pushing the body that way. And that's not going to happen if you just hit the arm. It's not enough force. It's not the right mechanism to actually cause the body to somehow move that far over.
So that was Trooper Paul's testimony that that's what happened. That's what the jury has to go with. Trooper Paul said, this is what happened. And now we have an expert that says, no, absolutely not. This is the definition of reasonable doubt. 100%.
With enough force at center mass to project that body.
What kind of injuries?
What injuries would you expect to be produced on that body?
Objection.
Sustained.
There's nothing wrong with that.
A body that was projected a distance. What injuries from a car? What injuries would you expect to see on the body?
Objection.
I'm going to see you at sidebar the last time on this.
This is just making no sense. A distance. She did the same thing with Dr. Wolf. Like, it's going to depend, isn't it? If a body gets projected 5 feet, you would expect to see different injuries than if the body gets projected 30 feet. So they have the last time on this. Facts,
yeah,
not in evidence.
she's such a the last time on this. Oh, I know. It's condescending freaking.
You have my question in mind? You need me to repeat it?
Maybe repeat it, yeah.
Easy for you to say. Assuming that a body was struck center mass with enough force from a vehicle traveling at whatever speed to project the body off the ground, would you expect to find injuries on that body?
You would, and you would actually see that there's specific injuries because let's say you're standing forward and you get hit on the right side with the vehicle. You're going to get injuries and damage to the right side of the vehicle as that vehicle impacts you.
Well, and then so back to, we're talking about the DNA stuff. The person took multiple swabs and just went all over that's what she testified she did. They didn't send the actual shirt. They just went like this with multiple swabs and then sent it to the lab.
Depends on the profile of the vehicle, how high the hood comes up, whether you're going to wrap up onto the hood, or if it's a van or the back of an SUV.
Absurdity after absurdity after absurdity.
It will project or push your entire body to the left. So you're going to get initial contact injuries to the right side of your body. And then if it propels you into the air, you're going to get airborne and then you're going to contact the ground, usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well.
Yep.
And
no, exactly. If you should, try it out on the butcher paper. Exactly. No, I agree. And I'd like to see this. I know that the whole LE law enforcement being able to deceive suspects, especially under, when they're questioning them, they can lie to them. They can absolutely straight out lie to them. And that is an investigative technique. It has been sustained by the Supreme Court, said that this can happen. But you're right. You should see something that DAs should not be able to lie, straight out lie to
you would also see
a jury.
Greater abrasions or road rash along the entire part of the body as your body then would slide until it came to the point of rest.
And you did not see that evidence.
Objection.
Thank you. They have one? Yes.
We already know they didn't.
And
I don't know what these limitations.
My next video, a couple of videos ago, we went through Lolly's closing arguments and we wrote down all of the lies. And so now I got to go. I'll try and get to that this weekend. Is find the spots in the testimony where it shows that he absolutely lied, because it's there. It's absolutely there.
This is nuts.
Absolutely there that he lied during his closing arguments. All right, here we go. Now this one, it's just right. Why they didn't take samples from his arm? They didn't. There's
Good afternoon.
so much ridiculousness.
Did you consider that he wasn't flying through the air and was just moving his feet in a roadrunner motion until he came to rest?
Testing in this case, you wrote a report, is that right?
We did, yes, sir.
And that report, was issued on February 12, 2024, is that correct?
I believe that's correct, yes.
And within
think about that too. So think about that too. February 24th, right? Is that what he said? Let's go back. February 12th.
February 12,
Sorry.
2024, is that correct?
They just did their report this February. So that should tell you that since this trial, we're just going to see so much news. It's just going to be news after news coming out. But I think I'm waiting for the big shoe to drop from the FBI, from the feds. And I'm hoping, trust me, what I've seen over the last 6, 7, 8 years from the FBI does not leave me with any kind of hope. But there's a little bit of hope that they'll do the right thing in this case and we'll see some kind of action, because
I believe that's correct, yes.
Between this, the Birchmore case, it's just, there's so much rot. There's so much bad going on in this part of Massachusetts. It's really, really disheartening to see.
And within the first paragraph of that report, the last 2 sentences state, this analysis is based on information currently available to ARCA and is only to be only to be issued in its entirety. However, ARCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
I believe that's correct, yes, sir.
Now,
he's going to do the same stuff that he did with the last guy that was objectionable.
As a team, that included some state police reports. Is that correct?
Yes, sir.
Some Canton Police Department reports, correct?
Yes.
Some scene photos. Is that correct?
Yeah.
That's correct, yes.
Yeah.
Medical examiner dispatch removal report. Is that right?
I believe so, yes, sir.
Some videos from the location of 34 Fairview Road. Is that
Watch, as soon as he gets to the part about his hat and his shoe, they're going to go to a very long sidebar.
Vehicle, the 2021 Lexus LX 570. Is that correct?
Yes, sir.
Photographs of evidence that was recovered from the scene. Is that correct?
Yeah,
correct.
right. No,
CPR
exactly.
reports,
This
from
guy
the
can
defense
answer
Lexus.
medical
Yes.
questions.
And then essentially there were some other materials, whether they be literature or other things that you and your team of other doctors reviewed over the
Right.
course.
Just the timeline between his opening and closing statements, where she supposedly hit him around 12:45, and then that gets blown up completely within the first, at least by the time Guarno got on the stand, whatever his name was, got on the stand and said she connected to the Wi-Fi at 12:36.
Correct?
That's correct, yes, sir.
Now, in regard to evidentiary materials that indicates within the report that were reviewed, you talk about the lens cap to the tail.
Oh yeah, there's the leg shake you were talking about. Leg shake.
Straw that was found on scene, correct?
Yes, sir.
There's no mention in the report of either Mr. O'Keefe's shoe or his hat, correct?
Here we go. Objection.
Yes.
May we approach?
You are muted.
Watch.
Ask and answer. We're
So-
gonna do
So this
all the
part.
same stuff again that we just did with the last.
Yep.
There would
I
be.
think this is
already got it.
this is a really long.
I
How
saw
many
from the
times I
chat
gotta
on the
hit this?
prominent disagree that the separate office.
Do, do, do,
he doesn't
do.
care.
I mean,
So
this is a
wrong.
long one.
Mr. Lallier, do you need a minute?
No. Oh, no.
No.
So he got shut down. He had to completely stop all that crap with the hat
Did they
and the
hopefully cut him
shoe.
off from a lot of this junk?
Oh yeah. No, they're not going to let him get away with the same stuff he did. Oh, yes. I believe you're right. And yes, I believe you're correct. And he did. He supposedly gave her a shoulder a shot. Just walked by her and gave her one of those, here's a shoulder. I mean, what a scumbag. That's just scumbag. Freaking. Yeah.
What I learned about the Sandra Birchmore case was from listening to the case podcast.
Doctor, are you familiar with a term called?
So if you're interested in that, check that out.
Compression abrasions?
Yes.
Yes.
And am I correct when I say compression abrasions are essentially when direct pressure from a blunt object together with slight rubbing movements produce skin and epidermal crushing? Is that what your understanding of the term is?
Yes, sir.
And you're familiar with patterned abrasions?
I am, yes.
And patterned abrasions are injuries that show a distinct pattern that may reflect the shape of the impacting blunt objects.
Oh,
that you may
yes,
see,
yes.
reference to injuries that are left by that blunt object. Is that correct?
Yep.
That's correct.
That is another very good video.
Now, as far as in general terms, from what you reviewed, at any point in time, did you look at a state police reconstruction report?
I don't believe that I did, no, sir.
You weren't provided with that, is that correct?
Why would they give? So, can you imagine? Let's just imagine for a moment that you give Dr. Rentschler and Dr. Wolf Trooper Paul's reconstruction report. That's what Lolly's asking here. Lolly is asking, did you see the Massachusetts State Police reconstruction report? Now, imagine for a moment you would them reading this report and how much laughter there would actually be, because they would probably be on the floor for probably a half an hour. I mean, you'd probably do it over coffee, you'd have it in a conference room. I could picture it now. You pull it up in a conference room because like, okay, folks, we're going to take a look at Trooper Paul's report here. And they pull this up in a conference room on a big screen TV, and they've got coffee. It's first thing in the morning. And they start to go through this report, and they read all about these things that Trooper Paul came up with, and then they proceed to laugh. They proceed to laugh for a long, long time.
That's correct.
Because
I don't believe so.
You weren't provided with any sort of forensic reports, DNA or anything like that, is that correct?
I don't believe so, no, sir.
And that's it. That's all he gets to ask. You didn't see them, period.
And you never actually looked at the physical car, is that correct?
I did not. That's correct.
And you're aware that the physical car, being the defendant's car, is still in law enforcement custody and available for inspection if you had wanted to? Are you aware of that?
I think I'm aware of that, yes, sir.
Did you never make that request, is that correct?
That was not necessary in this case to inspect the vehicle.
It was necessary or not, you didn't make that request, correct?
I don't remember if we made that request or
They
not.
didn't
We
pad
obviously
the bill,
didn't look
Mr.
at
Lally.
the vehicle, but it wasn't necessary in this case.
Did you ever look at the actual taillight piecings or pieces or the taillight housing, is that correct?
Not the actual. We looked at photographs of the evidence, yes.
condescension,
Injuries
more
to the
condescension.
Or reviewed in materials in regard to Mr. O'Keefe were primarily on the right side of his body, is that correct?
Well, sir, on the right arm and the posterior aspect of the right arm, yes. And then the skull fracture was a little bit to the right, the occipital fracture.
Also bruising on his right hand, is that correct?
There was bruising on the back of his right hand,
On
yes.
the dorsal aspect?
Yes, correct.
And there was also bruising on sort of the posterior of his right knee? that correct?
There was a small bruise, I believe. Yes, sir.
Go back and find that here in a minute.
So
They
what, now
should
he got hit on the left
probably.
side and somehow
Now,
got all those injuries on the right?
Yes.
Landing?
So, yes, Kevin Albert. So they actually revealed, if you read it now, which I didn't catch this until later on, Linda, that because I've got it up right here. Follow up on this. On 6/12, Michael Proctor was confronted on the stand about getting drunk with Kevin Albert on his thing. On 6/13, Kevin Albert was placed on administrative leave from the Canton Police Department. They didn't announce that. Nobody announced that he was put on leave. On June 13th, a month ago, almost a month ago, he was put on leave. So they finally announced it tonight, which is just, I mean,
with respect to
He doesn't know what he's getting.
bomb dropping, man. Just bomb dropping as far as I mean, it's so nuts. It is so nuts that and they finally announced it. Oh yeah, we're, you know, and until the I like this too. Thanks again to Sleuthy Goosey on X. They're looking into his role in investigating his actions in an investigation conducted approximately 2 years ago with Michael Proctor. Sure feels like the feds are swooping in. So they're basically putting him on paid administrative leave until the outside investigation is completed. So I mean,
right arm and forearm, correct?
Yes, sir.
Nuts.
In relation to
Absolutely
those injuries, there's a
crazy.
sentence in which you or whoever authored this part of the report, assuming that you indicate that furthermore, any such injuries would be highly improbable if Mr. O'Keefe was wearing a jacket, correct?
Yes, sir.
Are you aware that Mr. O'Keefe was not wearing a jacket other than a long sleeve sort of hooded shirt?
I believe that came to light afterwards. Again, I mean, it doesn't affect my actual opinion.
Yeah, I know they had kicked that guy out of the court, and
In this case, but it was a sentence.
oh yeah,
And so,
no,
also within
absolutely.
your
The
report, same
feds,
paragraph,
they've
you
got to
indicate
be
one
that
DNA
outside
transfer
end.
would also be
Yeah,
highly probable under such
absolutely.
circumstances, none of which were reportedly found on.
And who, because he would have had minimal involvement in this case, right? So, you know, but I'm sure he did have, you know, he was in the background of this case. Don't think he wasn't. He was pulling strings in the background of this case too. But I think in the Birchmore case, which I think, you know, it feels like that's what got the feds looking at this. And there could be other cases. There could be other cases too that under Morrissey that need to be looked into from the feds, because there's
Correct.
Are you aware that
there's
DNA,
there's some disgusting rot going on in this area of
consistent with that
Massachusetts.
Mr.
It
O'Keefe was
just
actually found
is.
on the taillight housing from the defendant's vehicle?
I'm aware after we wrote or issued the report that it became known to us that I believe DNA was tested and some DNA was found. I believe a small amount. I don't believe any blood evidence was located or found on any pieces. But there was indication of DNA on the taillight housing.
Oh, he just wants
There
to
was also
totally
DNA,
get
matching
this.
Mr. O'Keefe that was found on the exterior
Yeah.
of a piece of drinking glass that was found right near his body.
No, right. Other hearing or other procedure or, you know,
I believe
yes.
so,
No.
yes, sir.
And there was also pieces approximately 16th of an inch by 16th of an inch of clear and red plastic that was subsequently found to be consistent with the defendant's taillight
Yeah.
that was found embedded within Mr. O'Keefe's shirt.
I'm pretty sure
Within
they
the shirt, I
are.
believe, yes, sir. Not his actual body.
Although that was funny that, you know, they're not allowed to say the FBI or not allowed to say DOJ, but it was funny that Colin let that slip on the stand. Oh yeah, the FBI or the feds, or I think he said the feds. I think he said the
And so
feds.
this was all things that you found out.
He
after
let
you
that
issued your report
slip.
in February of 2024, correct?
That's correct, yes, sir.
Okay, so just trying to figure out, that's why we're here, trying to figure out why the jury would still come. 8 people think she's guilty
Sir. Not his actual body.
of manslaughter.
And so this is all things
Why?
that you found out after you issued your report in February of 20,
So
Within the shirt, I believe, yes, sir.
Mr. O'Keefe's shirt.
Within the shirt, I believe, yes, sir. Not his actual body.
this is normal, right? Did I
And so
put
this is all
normal?
things
Gosh,
that
these
you
people are
found
talking
out
slow
after
now.
You issued your report in February of 2024, correct?
That's correct, yes, sir.
So could this part sway the jury? I mean, it's a tiny little piece, right? He brings out that 16th of an inch by 16th of an inch.
I believe so, yes.
And there was also pieces of approximately 1/16 of an inch by 1/16 of an inch of clear and red plastic that was subsequently found to be consistent with the defendant's taillight that was found embedded within Mr. O'Keefe's shirt.
Within the shirt, I believe, yes, sir. Not his actual body.
And so this is all things that you found out after you issued your report in February of 2024, correct?
That's correct, yes, sir.
I mean, it's thin, right? It's thin, very, very thin. But somehow this jury still felt that there was a manslaughter charge that she was guilty of. Somehow 8, if we believe the filing, that there are 8 jurors that felt that she was guilty. And we'll go look at that again because I've got it right here. We've got it right here. Let's go back. There's charge number 2. All right. Manslaughter while operating a motor vehicle under the influence, right? So guilty of manslaughter while operating a vehicle under the influence, manslaughter, alcohol, blood greater than that, guilty of lesser included, involuntary manslaughter. So in order for her to be guilty of these, she has to have hit him with the car. And so how, I mean, this testimony is so strong to blow out everything that the prosecution tried to get through.
Now, when you were talking about the
was it just, how is this not enough? What part of this is not enough?
Of Mr. O'Keefe, consistent with coming in contact with a hard surface, correct?
Yes, sir.
Would that hard surface include if the ground was frozen?
Yep. No, correct. That was the day after the testimony of Proctor being on the stand and them getting drunk, and he left his badge and, oh my gosh, did you find my gun? What? I mean, who are these cops, man? Who are these cops that would do that?
You'd have to perform an analysis, actually, because you'd have to determine how hard that ground was.
Thank you very much. Thank you very much for coming. Appreciate it.
Look at ground and say, well,
thank you. And yeah, we'll keep doing this. We'll keep doing. We got all kinds of fun stuff planned.
It may be, but you have to go through an actual analysis and procedure to determine how hard that ground is and whether it could have produced those injuries.
So it is something that's capable of being done by you, is that correct?
Performing that type of an analysis? I mean, you could go through and do it, sure, yeah.
And you didn't do it, correct?
Yeah.
No, I did not do it, no, because, yeah, there's no need in this case. We don't know what happened in this case. There's no indication.
Yeah, exactly.
Certainly, it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there, and the damage with the car is
it's just not possible. Like they even say it's not possible.
Consistent with him getting
yes, have a good night. Have a good night, D-Mart.
The roadway could cause it, the curb could cause it, a back could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided, isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened. Thank you. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
When was it that you looked at this additional material, and who provided it to you?
We were informed after a report was issued that DNA was found, and that was really the primary issue. I believe that some DNA was found on the housing, which, again, there's numerous explanations or ways that DNA can
you really
get
want to ask
on the White House.
Lally?
Let me ask you this, sir. With regard to the materials that you were provided with, was there anything in there that stated that Mr. O'Keefe's skull fracture on the back of his head was caused by contact with the taillight?
Yeah, no, they absolutely said that too. There would have been there wouldn't have been touch DNA on him. There would have been blood. There would have been embedded in his arm, right? Just so ridiculous.
No, I don't believe there was anything in those materials that stated
Is there
that.
anything in those materials that indicated, or that anyone stated at any point in time
More
that Mr. O'Keefe's arm
condescension.
was outstretched at the time that he was struck by the vehicle?
No, sir, there wasn't.
Was there anything in there indicating that his arm was tucked in at the time that he was struck by the vehicle?
You know, there's no indication in any of that evidence of what he may or may not have been doing, how he may or may not have been positioned. I mean, that's the whole issue. There's no evidence to indicate what may have allegedly occurred in this case.
Now, a typical pedestrian collision that you see through the course of your work involves a pedestrian being struck by the front of a vehicle. Is that fair to say?
I see all types of different people getting run over backwards, cars spinning, hitting sideways, frontal impacts certainly occur, yes, but we see pedestrians getting struck by all parts of the vehicle.
I'm sure you see all kinds. What I'm asking is predominantly when you see a pedestrian collision, the typical pedestrian collision would be a pedestrian crossing a road in front of a vehicle as it's approaching. Is that correct?
Why does it matter?
That's certainly not uncommon, yes, sir.
Now, as far as you maybe described a little bit on your direct testimony, as far as there's differences in the type of injuries that you would expect or anticipate depending on how the vehicle interacts.
Right.
With
Exactly.
the pedestrian collision, correct?
Yes, sir.
And as far as you're familiar with what's called the sideswipe collision,
Yes, sir, I am.
and am I correct when I say that in a typical pedestrian collision with pedestrian crossing in front of a vehicle, there are a number of different types of interactions as far as a wrap and a forward projection versus a fender ball versus a number of different ways that a pedestrian can interact with the front of a vehicle, correct?
It depends on the position of the pedestrian and certainly the profile of that vehicle and the speed of the vehicle. Yes, sir. There's many different factors involved in it.
And so in a typical pedestrian collision, when a pedestrian is struck by the front of the vehicle, that involves more of an assumption of the velocity of the striking motor vehicle by the pedestrian than you would expect to see in a sideswipe collision, correct?
Well, I mean, yes, generally speaking, a sideswipe means that the person or the pedestrian, the vehicle don't obtain a similar or common velocity. So if you're standing in front of a car and it hits you, it's going to speed you up to that same speed and then disengage. The sideswipe means that there's not this mass-to-mass impact. By its very nature, sideswipe has minimal forces. We see it even between vehicles that just rub against each other. So if there's a sideswipe impact with a pedestrian in a vehicle, there's going to be very little damage to the pedestrian. And similarly, there's going to be very little movement. There's really no force at all acting. You know, for instance, if a car came and swiped by your arm, but didn't have enough force or enough contact to cause any damage, well, it wouldn't actually cause any movement of the person either. So a sideswipe by its very nature involves minimal impact, minimal forces, minimal velocities.
I don't even understand what Lolly's trying to get at here. Is he like trying to, their whole testimony and Trooper Paul's whole testimony was that he got hit on the arm and knocked on his head and then thrown 30 feet. So where does this come from?
Also contained in the reports.
I really hope so.
There's an indication that Mr. O'Keefe's injuries, at least to his skull, the fractures to his skull, are consistent with him having been pushed or possibly been impacted by the subject Lexus and fallen backwards, striking his head. Isn't that correct?
Yeah, so that's another possibility.
Sorry, sir, yes or no?
No, let him answer. Let him answer the question.
So,
All right, here we go. This is it right here. This right here should have, I mean, this is the last thing far as testimony the jury hears. This is it.
With skull. In the reports that you at least co-authored, there's an indication that Mr. O'Keefe's injuries, at least to his skull, the fractures to his skull, are consistent with him
this is it.
having
This
been
is
pushed or possibly been impacted by the subject Lexus and fallen backwards, striking his head. Isn't that correct?
yeah, so that's another possibility.
Sorry, sir, yes or no?
No, let him answer. Let him answer the question.
So if we're saying that there's enough,
what's hilarious too is Lolly asks this long, drawn out, open-ended question, which is not a yes or no question, and then expects a yes or no answer. What it?
No, let him answer.
This
Let
is
him
a-
answer the question.
so if we're saying that there's enough force if you fall backwards to strike your head and cause that skull fracture, well, he could have slipped and struck his head. The car could have backed up and not known that he was there and nudged him and caused him to fall. I mean, any event that would cause him to fall backwards obviously would result in.
The only thing I can say is could this have done it? Could this have been the linchpin that the jury
Could
needed?
have slipped and struck his head. The car could have backed up and not known that he was there
But-
and nudged him and caused him to fall. I mean, any event that would cause him to fall backwards obviously would result in him striking his head. So there's a numerous, almost infinite possibility of different scenarios that could result in that type of an event.
Which is reasonable doubt. This guy just said reasonable doubt.
Okay.
Yes, you are
Mr.
correct.
Jackson?
And that's the end of his questioning.
Okay. Dr. Renchley, you are all set, sir.
Thank you, John.
Okay.
Defense
First,
rests.
I want to see counsel for the last.
All right. That was the testimony of the two FBI experts in this case. That was their testimony. That was the testimony that most observers of this case, most of the commentators of this case lawyers that watched this case, Runkle and Emily and Andrea here and Melanie Little and, all of the other ones, these two experts were, that was the biggest part of establishing reasonable doubt that it just didn't happen, that he didn't get hit by a car. But yet somehow jurors in this, eight of them were ready to, and I totally appreciate the four that stuck by their principles, right? Because how does he end up by the flag? They don't understand it, and then they just, and that's part of the jury instructions, right? The jury instructions that they got were completely confusing. And so, and there was no doubt that all of them were drunk. All of them drove drunk. Everybody involved in this night had some level of intoxication. Now, we can get into the whole what Buchey watched as what Buchanan watched as far as, his little, he poured this drink in and then she poured this drink into her glass, and 8 or 9 vodkas when she only got charged. What bartender is only going to charge somebody 2? I think it was 2 that were on the receipt, yet she supposedly drank 8 or 9. No, they're not going to give her free alcohol all night. I'm sorry, that's just not the way it works. But still, you saw both of those folks testify just now, and they still were 8 of them, and it was 6-6 initially. And if we believe the filing, which is right here, this was the screenshot of the text messages. No consideration for murder. 2, manslaughter. Started pulling at 6-6, then ended up deadlocked at 4 no, 8 yes. I still don't know where or how you get there. Right. Yeah. No, exactly. Drops him off down by the flagpole, and then she's gonna, and then nobody sees him when they leave the house. And it's just, there's so much. But yes, back to this. She should actually absolutely be acquitted of this. I don't know. It's still so perplexing. And look at how much news has come out. Now we've got, Evan is on paid administrative leave, but you've now got Proctor, that having Proctor put on unpaid suspension is a big step. That is a big step as far as the state police trying to do the right thing. Obviously they haven't done the right thing a lot, because there is a lot to clean up. And if Proctor is going to be the only fall guy on this whole thing, I'm sorry, but there were people on those text messages. There were people that performed a lot of this investigation, and there are a lot of people that performed parts of the investigation in the Birchmore case, like the cell phone guy who couldn't find the text messages between Sandra Birchmore and the officer who got her pregnant. I'm sorry. Yeah, no, exactly. All the cameras in the neighborhood, the cameras that just don't, all of a sudden they're not, that camera's not available, or the missing footage from the library camera, which all of a sudden, oh, it just, I don't know how that happened. Or the Sallyport video coming in mirrored. And then for Buchanan to have the gall to get on the stand and say, well, it's not backwards. If you look at your face in the mirror in the morning, you're still looking at the same face. No, it's backwards because you made a point during your direct examination to say that you guys weren't near the taillight when the opposite was the fact. When the video was completely backwards. It was completely opposite. So don't tell me that you guys weren't near the taillight because that showed you were near the taillight. Yeah, I know. Oh, I know. That was so funny. Oh my gosh. So much crazy. This whole trial, man. Oh yeah, no, exactly. Yeah, and you've seen the videos of him at the wedding, right? Oh yeah, the at the wedding where he's got his shirt off and he's doing that's the guy, right? Oh man. Yeah, I have to look that up for the next time. Yeah, I really hope so. I really hope so. I hope somebody comes clean on this. I really do, because I mean, it's amazing that they took this to trial. It's amazing that I mean, I don't know. It's just what we witnessed throughout that entire trial was just, I mean, it's just so absurd. It's just you couldn't write a script. You couldn't write a script that was this insane. You just couldn't. All the stuff that we saw happen in this trial, all of the crazy testimony, all of the just the butt dials alone. Everybody butt dialing everybody. Somebody butt dialing somebody, what was it, 9 times in a course of 20 minutes, I think, that Jen McCabe called that phone. I mean, it's all insanity. But there's nothing in that testimony. Yeah, I hope somebody does. I think if Proctor, maybe he sees himself as he's going to be the fall guy and he comes clean about, what he did, and I mean, yeah, even the timing, where they use the, part of the phone that they use, like they use the Waze app from John's phone, which was off time, is like 4 minutes off. I mean, there's just so much stuff at this trial. Yeah, exactly. There you can, and how do you let a person on the stand, a witness on the stand, sit there and give commentary on what you're seeing on a video? That's not supposed to happen during a trial. You're not supposed to be able to sit there and give commentary, especially on a video like that where you couldn't see it. He's pointing out all these things where, oh, now she gets this little glass and she dumps it in there, and so you couldn't see that. Nobody could see that in that little bit of thing. But I go back to it, is that somehow 8 jurors were ready to convict her on manslaughter. It just does that of all the craziness that we saw in this trial, that 8 people were still ready to convict her of manslaughter blows my mind. It's probably the most absurd thing of this trial, of all the absurd things on this trial, that you still had 8 people ready to say that she was guilty of manslaughter. I don't, I'm to the 4 people that stuck to their guns and said, no, she's not guilty of this. She didn't hit him with it. Kudos to you folks for keeping your principles, because that's the people that we need on juries, that are going to look at everything with a critical eye and not just say, because the state has brought charges, that somebody's obviously guilty of something. Because I would think that's what some of these folks said. They're still thinking that because the state brought charges, they have to be guilty of it. This is a confusing mess anyway. This is a completely, I don't even know what the check one or both of the, so I guess if the guilty of the offense of manslaughter while operating a vehicle under the influence, check one or both of the following: manslaughter while operating a motor vehicle under the influence of alcohol. And they did change this to say not guilty of the main charge or the lesser included charges, but that still doesn't, I thought there should have been a not guilty for each one of these, but still motor vehicle homicide. So they still had to think that she hit him. And I don't see how. I don't see how. Unless looking back, maybe the last statement that he did say, where, let me get rid of this. Back to here. I want to hear that one more time.
Possibility of different scenarios that could result in that type of an event.
Okay.
Of differently would and nudged him and caused him to fall.
That's the only thing.
Not knowing that he was there and nudged him and caused him to fall. Any event that would.
Him saying that, maybe that gave the jury something that they could go on. Maybe. That's the only thing I could think of, is they did hear him say that maybe he
could have backed up and not knowing that he was there and nudged him and caused him to fall. Any event that would cause him to fall backwards obviously would result in him striking his head. So there's numerous, almost infinite possibility of different scenarios that could result in.
Of course, they never opined that he could have gotten hit in the head, right? Or he could have gotten struck in the face and knocked backwards, but
that type of an event.
I don't get it.
Okay.
Thanks. So, maybe that wasn't the mic drop that we all thought it was. Maybe that gave the jury just a little something to go on. I don't know. I don't know how they still get there. I was hoping maybe there was something I missed in these 2 guys' testimony. You put this with Dr. Where was that? Yeah. One more absurdity before we go for the evening. They bring up the transcript. The transcript's so helpful in these things. And I wanted to find the
I saw from the chat. Here's
where is it? Where Lolly asked about it was, maybe that was the day before, where he had Dr. Russell on the stand. It must have been the day before, or he had Dr. Russell on the stand, and the whole thing about the Boston Globe subscription. Just, he should have been written up for that thing. Yeah. Anyway, all right. Well, thank you everybody. We've been going almost 3 hours here. I think I am going to head to the branch. But yeah, no, yeah. They don't, things just don't line up here. They're not. They don't make sense. None of this makes sense. The whole thing doesn't make sense. I don't know. But hey, I thank you very much, everybody who's been here. Everybody, thank you for all the great comments and the great back and forth. I truly appreciate it. And I think tomorrow night we're going to do something completely different tomorrow night. We did a little skit here this last weekend, and we're going to edit it tomorrow night right here live. So if you're around, tune in. We'll have some fun, do something completely different. Oh, yes. Thank you. Thank you very much. Yes, please give us a like on the video. Please subscribe to the channel. And appreciate everybody. Appreciate all of the interaction that we've been getting. It's been really great. So, and on that note, I shall see you all later. Thank you again, and we'll see you soon. Okay. Good night.